Good morning, everyone. Welcome to the Appellate Division First Department. We have oral arguments for today, Friday, November 7. So as you all know, please ask for the time that you need to get out the salient, most important points of your argument. Please keep in mind that we are familiar with your arguments. We have read your briefs as well. People v. Rafael Jimenez. That matter is submitted. SKMF Vice Management versus Knobloch. Respondent? Okay, 6 and 2 and 6. Justice Higgett is recused on that matter. Matter of AI Children. That matter is submitted. Hanslick v. UG2. 525. Oshan Frame Woloski LLP versus Kastenbaum. 525. Jones v. River Park Residences. 525. People v. Armando Cruz. That matter is submitted. Molina v. Mount Sinai Morningside. 5, 2, and 4. Greenway Muse versus Liberty Insurance. Yes. 3, 1, and 3. People v. Angel Soto. Angel Soto.
Morning, Your Honor. Respondent request 5.
424. Ovachkian versus Ovachkian. That matter is submitted. D. Justice. Are you the appellant? That matter submitted. Thank you. Parquet Solar v. Angel SPA. You have a cross appeal? 5251. Rockwell v. Boops.
Can't hear.
So, yes, the respondent is virtual. Can you hear us? Yes. How much time are you requesting?
She's muted. She's muted.
You have to unmute. Can you unmute?
I did. I apologize, Your Honor. Cassell McSweeney here.
I'm sorry. So how
On
much
behalf
time?
of respondent.
Yes. How much time are you requesting?
10 minutes, Your Honor.
Okay. So that's 6 and 2 and 6. That matter will be called first. People of the State of New York, extra Margaret DeRocha. 626. People v. Inglio Ariana. Matter is submitted. Arjun v. De Jesus. 424. Robinson v. Delgado. 424. People v. Daquan D. 6 and 2 and 6. Matter of Strasser. 525. First matter, as I stated, is Rockwell v. Boops. Yes.
May it please the court, it's Steve Younger, counsel for the appellants. Here the plaintiff was paid $4 million in exchange for a broadly worded general release. Despite this, she now wants to bring claims that were waived by the express terms of that release. Controlling case law requires the court to interpret the language in the release. And that's where the lower court went wrong. The lower court looked outside the release and looked at extrinsic evidence and found an ambiguity, whereas
Well, was this claim viable at the time of the release?
it was not, but the express language says any claim that you had in the past, which it would include a unviable claim, or may have in the future, which would include a claim that's not viable now that would be revived later.
Counsel, what effect should it have on the fact that the claim was revived by the legislature?
I don't think that matters at all, because what the language of this controlling case law says, including Professor Siegel, when a claim is untimely, the claim still exists. It's just that you don't have a remedy. So all that the legislature did was to unwind the statute of limitations. It didn't mean that that claim didn't exist and wasn't wiped out. I submit that this case.
So can I ask you, for example, obviously it's a CVA case, so we're all cognizant of that, but this person could have brought the claim at the time she signed the release, correct?
Yeah, she could have brought the claim. We would have
So she
argued it was
had the claim
untimely,
there, right, right.
but the claim existed.
And she had the claim years before she signed the release.
Years before.
And she could have timely brought it at the time of the terrible, horrible incidents, correct?
Correct.
And she didn't.
She didn't.
And then she signs a release that says, I release all that for, and is she represented by counsel?
Represented by counsel, and tells the court she understands she's waiving any further claims against the estate. That's record page 53,
And what year did she sign that release?
2012.
2012. Now, in 2025, 13 years later, she wants
Oh,
to...
2021.
Oh, 21. You're right. You're absolutely right.
That's okay.
She wants to unwind that 10-year-old release.
Exactly.
So that would mean that any time the legislature revived a claim or extended the statute of limitations, people could go back for years and years and years and unwind releases.
And by the way, there are two decisions on point, the ARC 247 case and the MM case in the CVA context, which say, just because your claim was revived doesn't mean you don't apply general principles of interpreting a release. I think this case is on all fours with the Trump case. In Trump, Your Honor said the party settled a probate case. The plaintiff later came along and said, I thought I was just settling the probate case, but she had signed a general release, and the court said unknown claims were barred. Here she knew of the claim. So
Was there any claim of fraud here?
No claim of fraud. I mean,
Well, the Supreme Court did find that the release was ambiguous.
yes, but they used the wrong analysis. The controlling case law says you look at the words of the release. The court never construed the words.
Well,
of
the court also stated that it did not appear that there was some question as to whether or not there was a meeting of the minds as to the terms of the release.
Well, the court relied on two things. One, a release that plaintiff's mother had signed, different parties, but more importantly, it said that release mentioned Mr. Bopst by name.
Right. Well, that was the other issue because it stated, I think the court stated that the 1979 release signed by Hiley in connection with the 1978 litigation released Elmer as an individual, whereas the 2012 signed by plaintiff did not.
Here's the problem. When someone's dead, there is no claim against them. That's not disputed by the plaintiff. The controlling case law says that when someone dies, your only claim is against their estate. So that if you hear there's no question that all the parties in this case were named. In fact, she told the court she would never sue the trust, and she's suing the trustee in this case. But when the law says you have no claim against a dead person, you only have a claim against their estate, and the estate is released, that's just a complete irrelevance.
Well, yeah, I understand what you're stating, but the argument is that she did not realize that she was giving up her right to sue Elmer, her grandfather, individually, as opposed to the trust in the estate.
But that's not what she told the court. She told the court under oath she was waiving any further claim against this estate. And mind you, she admits at page 4 of her brief.
Have we ever found that just because you don't know what you're giving up, and if you're represented by counsel and you get millions of dollars in exchange for the release, that you can 13 years later undo it?
In fact, you've held the opposite. In Trump, you said you don't even have to know about the claim. Here she knew she had a claim. She thought it was time barred. But just because you know, some circumstances change does not mean that you all of a sudden get a new right. The second thing the lower court relied on is that there was apparently no discussion of the sex abuse claim. If you get into that, it's a very dangerous precedent for releases. If you have to show that parties discuss particular cases, claims before release is signed,
Would someone have to waive their attorney-client privilege to prove whether or not they discussed an unpled claim?
that would be a tough situation, Your Honor. In fact, in the MM case, squarely on point, you had a case that was released against a priest. Later on, they bring a claim against another priest. And the same argument was made. I didn't think that I was waiving my claims against the second priest. I only thought I was waiving against the first.
So, Mr. Younger, is it a possible argument that in the release is waiving in terms of monies owed or monies due as an heir of Mr. Boops, as opposed to monies that as opposed to an action for personal injury or for sexual conduct towards her? Meaning the release was only as to the money in the estate and how that money should be divvied up, as opposed to he sexually abused me and therefore that's a totally separate action.
The case law says if that's what you want, you have to accept that out. This release said all claims relating to this estate or the assets of the estate. She wants to go after
Relating
the
to
assets
the
of this
estate or the assets of the estate in terms of the any inheritance.
That's not what it
In terms of the
says.
way the monies are going to flow to the individuals, to the relatives.
Yeah, if that's what the release said, we wouldn't be here. The release, and by the way, remember, she stood up and told the surrogate, I'm waiving any further claims against
But doesn't that
this estate."
possibly go to the Supreme Court's analysis that there's ambiguity? That it's ambiguous as to whether or not the release is just as to monies that flow, again, to the relatives, as opposed to monies which would flow in terms of any action for, as I said, for abuse or something of that nature.
The problem is we are a four-corner state. There's nothing ambiguous about the release itself. She's trying to bring in these extraneous facts, and that's what this court rejected in Trump. Trump said, you read the terms of the release. If it said all claims, it means all claims.
Thank you.
Thank you, Your Honors.
Yes, you have 6 minutes. So could you address
Yes.
that? How do we deal with Trump, with that case, given our decision in Trump?
Yes, Your Honor. Well, the Trump case, sorry, I hear an echo. Is there
No, we're good.
any? Okay. The decision in Trump is distinguishable from this case. Essentially, it was a general release and they did look within the four corners, just like the lower court did in this case. Defense misrepresents that the lower court looked at extrinsic evidence to determine ambiguity, but it did not. Here, the lower court did look within the four corners and within the context of the agreement, which is allowable under case law. Now, in Trump specifically, the parties that were released were the same parties for which the subsequent action was brought against. Here, the parties that were released, the identity of the parties was the estate of Elmer Bolts. And the trust.
May I interrupt you, counsel? But not only the state, but all assigns and heirs, successors, not just the parties, a lot of other people. These people, are you saying that these two parties are not covered by this release?
Not for the sexual abuse claims, Your Honor. The sexual abuse was
Where
committed
does
by
it say
Elmer
that?
Bolts
Where does
during.
it, let me ask you, where does it say that in the release? Does it carve out anything in this release?
It doesn't carve it out, Your Honor.
It says
However,
everything,
based
right?
on, not necessarily, it does say everything, but it's as it pertains to matters related to the estate and testamentary and non-testamentary assets. I'd like to point out, Your Honor, that the estate nor anyone named in this complaint committed the sexual abuse. Elmer Bolts did during his lifetime.
So I
This
just
is not
wanna
even the case again.
So counsel, it states hereby releases each other and each other's heirs, successors, and assigns from all claims, causes of action, suits, debts, sums of money, agreements, or promises relating to the estate of Elmer H. Boops. So again, releases each other's heirs, successors. That seems to would include your client.
Your Honor, this is a clawback action, which means all the assets of the estate have already been distributed to the beneficiaries. So when we get to that point of damages where we do have an actual monetary claim against, for these assets, this is a clawback action, so it's essentially against the beneficiaries, not even the parties that have been named. I'd
Then
also like
why,
to point out, Your Honor.
then why sign on to a document that relates to all claims? Why not make it plain that the only claims this release affects are those claims in the surrogate's court?
Your Honor, it is, remember, the lower court held that this, the intention of the parties to release the instant sexual abuse claims is ambiguous, right? And therefore, we need to conduct more discovery. So these are questions that we do need to figure out on discovery.
So,
One of the
counsel,
things
have
that
we ever
defense-
held that a release like this is ambiguous? Have you have cases? I mean, I sat on both cases. This release is literally the same release. And we held it was not ambiguous in Trump. What's ambiguous about this? Plus, you're talking about this release itself says testamentary and non-testamentary assets. It could not be broader. And let me, right, is that correct? Let me stop myself and ask you, right? It's not only testamentary assets, it's non-testamentary assets.
Your Honor, to answer that question, yes, you're correct. It is non-testamentary assets as well. However, please understand that at the time, just looking within the four corners, it is questionable whether the party's intention was to release the sexual abuse claims against Elmer Bopes during his lifetime.
Can't we look at the
The courts say-
intention?
the courts say-
Counsel, let me interrupt you for a section about that intention. Don't we normally look at intention in terms of the four corners of the document? I mean, like every single contract when it's unambiguous?
To
We don't
determine
go outside.
ambiguity.
We don't look at parole evidence. If
You're correct, and sorry, there's a
No,
lag,
I know,
so I
it's
apologize.
a little difficult. I'm going to let you speak now. Go ahead.
Sure, Your Honor. This is my point. The lower court did not look at parole evidence to determine ambiguity. It focused on the four corners and the context. Even in the court colloquy with the plaintiff, in which the defense mentioned, the judge specifically said, and advised the plaintiff, you're waiving any further claims against the estate of Elmer Bowles and any of the documents that he signed or any other matter related to that issue. And so essentially, the parties at the time were not intending to, or at least it is ambiguous, as the lower court said, whether they intended to release the sexual abuse claims. It's also important to note.
But because
the plaintiff here is
Elmer,
not trying to undo.
but because Elmer had long since passed, any claim against Elmer by any tort plaintiff would necessarily have to be asserted against his estate. And again, we go back to the 2012 release that says all claims are causes of action against the estate.
And let me just say, Elmer died in 1995. So did he not die?
No, he
1970,
It was
1978. 1978. He died in 1978.
Yes.
So again, as my colleague just stated, everything would have to be, any claims would have to be against the estate.
Your Honor, the lower courts decided that it was ambiguous. It is up to the
Right,
defendant
and
to
so
show
our-
conclusively and definitively.
So we have to make a determination as to whether that is correct or incorrect. So why is it ambiguous, again, given the four corners of the release and what the release states?
Well, Your Honor, because of the fact that within the context of this release, it was a will contest. That was the underlying proceeding. This release was entered into as a result of the will contest, not as a result of any sexual abuse claims. There is case law that also is on point as to the fact that there were absolutely no discussions regarding sexual abuse prior to or during.
Counsel,
Defense has represented that.
Counsel, I'll ask you the same question I asked the adversary, and what effect do you suggest that the CVA had on your claim vis-a-vis the release?
Thank you for asking. So I want to point out the plaintiff is not trying to undo the agreement. She's simply saying that it's the claims brought forth, the sexual abuse claims are not within the scope of the abuse or were not intended to release by the party. The relevance of that is once the court determines ambiguity, essentially it's a demonstration or circumstantial to show that because the claims were not within the sexual abuse at the time that this
So,
2012
counsel,
release was entered into.
if I'm understanding you correctly, then what your response to my question is that the CVA and the revival has no effect on the release because this release didn't encompass the sex abuse claims.
Yes, and it circumstantially shows that it was not within the party's contemplation because it was a claim that was past the statute of limitations. So the parties could not have possibly contemplated the sexual abuse claims at the time this release was entered into.
So if we find this,
Therefore,
let me,
it is
counsel,
ambiguous as to intent.
if we find that the
Yes.
release is not ambiguous, then it doesn't matter either way, whether the CVA was enacted or not. Is that what you're saying? If we find, unlike the trial court, that this is an unambiguous release, then there is no effect of the CVA, correct?
Essentially, it cannot be considered because it would be considered extrinsic evidence. And I do agree with that. But the release is not unambiguous conclusively. The defendants have not shown anything in the record to demonstrate or to prove that conclusively the intent of the parties was to release the sexual abuse claims. They have to show definitely that it was. And that's why we're urging the court that the lower court made the right decision because we have to conduct a discovery. Something I think is important to mention, Your Honors, defense has represented that all the parties knew of plaintiff sexual abuse by Elmer at the time this release was entered into. There's nothing on the record to support that all the parties knew. That is something
But
that we need to conduct on discovery.
Perhaps not all the parties knew, but your client knew, and that is the important thing, right?
Well, not necessarily, Your Honor. That's only important if, sorry.
No, go ahead.
That's only important if the plaintiff subjectively knew and intended to not include the release and purposely did not carve it out. Our position and what happened was it was not the intention of any of the parties involved in the 2012 release to release claims pertaining to sexual abuse by Elmer Bolt.
But it all rises or
although-
falls. It all rises or falls at this juncture on whether we find that the agreement is ambiguous or not. And on that point, extrinsic evidence or considerations are irrelevant, right? We're looking at the four corners. Is there an ambiguity? If so, we affirm. If there is no ambiguity, then we have to figure out if we still have to affirm or reverse.
Well, somewhat, Your Honor. You find whether there's an ambiguity or not. If there is, then you would look at extrinsic evidence or parole evidence. Further, which I would like to get into if Your Honor allows, but essentially, one of the things I do have to say is we have to look at the standard, and it's a very high standard here on a motion to dismiss level, which is whether the defendants have conclusively shown or definitively shown that it was within the intention of the parties to release Elmer's sexual abuse claim, and they have not.
Thank you, Counsel.
Remember, there's a couple things.
Counsel, thank you. Yes.
You're welcome.
Thank you, Your Honors. So plaintiff doesn't deny that she was paid $4 million for a release that the express terms cover this case. In fact, she said they want to go after the beneficiaries of the estate, meaning to unwind the disposition of the estate assets.
No,
That's-
what they want to do again is that for the claim to proceed, and then any monies would have to then be clawed back. That's, I mean,
Right.
yeah.
But that's exactly
But
what she
that's,
released.
I mean, that's necessarily how it would occur because the monies were already dispersed.
Yeah, including to one of the defendants, the Bopes Foundation, which is covered by this release, was in the prior case, and she said she would not make any claim to estate assets, and that's exactly what she's doing here.
But Counsel, again, if there's a viable action, and as my colleague stated, if there is an issue in terms of the release being ambiguous, then that's something that would have to be dealt with down the line, right?
Yeah, I think that's a very slippery slope. If you start saying that language that is used every single day to settle cases in the state of New York is ambiguous, that's exactly what the court rejected in Trump. Just because someone comes along and later says, I didn't really intend to release this, that's irrelevant. It's what they signed on the piece of paper.
And both sides are represented by counsel, right? So
had-
counsel understands what the import of hopefully, what the import of a general release is, right?
And she told the court she had a chance to talk to her lawyer, and she had all her questions were answered. So this isn't a case where something was just slammed down. I just want to come back to the CBA.
You're
because
finished.
it-
Your time
okay.
is up, but thank you
Okay,
very
thank
much.
you, Your Honor.
We have the briefs. SKMF Vice Management v. Nyblock. Justice Higgett is recused on this matter. If there is a tie, another judge will be vouched in.
Good morning, Your Honors. Eden Burkett for the city. Your
So
Honor,
I have to ask you, counsel, you know, we've decided this issue post the first case that you keep citing, and we have a second series of cases that go the other way, correct?
correct.
So why would we reverse ourselves now? Or how is this case different? Let me ask you that.
Well, it's essentially the same case, but this court has come down diametrically in two different ways.
So
But
maybe
most
it's-
recently, we've come down against you, I guess.
Correct. That case is on appeal. The city has pending motions for leave in the Court of Appeals. And with respect, the city's position is that that decision is irreconcilable with the earlier decision, which was correctly decided. And
Although the
so,
second department has now issued about 20 decisions in the same way that our latest decision goes, right?
What is that? So that's like 26 to 1?
Right.
26 to 1, something like that.
well,
Or
the-
21 to 1.
well, with respect, this court's decision in 3061 was correctly decided, and the others were not. And there are pending motions. There are 10 motions for leave pending in the second department, and there are 12 motions pending. So that so there's many. The city has not has continued to appeal. Yet it bears mentioning that in the 3061 decision, this court decided petitioner did not seek leave to the Court of Appeals. Instead, after this court denied the motion for leave and re-argument, and after the Fordham Hill decision came out, they moved for a renewal in the 3061 on the premise that there was a change in law, and this court denied that. So the panel in 3061, which Justice Weber was on, denied the motion for renewal, did not recognize that there was a change in law. So with respect, the only decision that's final is 3061. The others are still pending. And I'd be happy to point out.
Isn't the better thing to do is just let the Court of Appeals decide this?
Well, I
No,
think there is one matter which several, I believe Justice Weber and Justice Higgett was on as well, which is the matter of bicoastal, where leave was granted, and it involves a different. It doesn't involve misclassification of vacant land. It involves a more evaluation claim, and so, so that case is pending in the Court of Appeals. The appellant's brief has been filed. The city's brief will follow shortly, and the city anticipates that the Court of Appeals will address the scope and extent of what is a clerical error or an error of description.
So can I just ask you one, because, I mean, we've ruled. I sat on the cases, the series of the 9 or 10 cases, but how do you respond to the allegation that you are not disposing of these consistently? You are not disposing of these cases consistently. Sometimes you're doing one thing, sometimes you're doing another thing. It looks pretty obvious that that is true. So how do you respond to that?
Okay, so I think that there's several ways that this argument has sort of come about. One is in the Fordham Hill decision, they said that there were inconsistent decisions, that some were on the merits and some weren't. With respect, there was no distinction between the cases. In fact, I looked,
No, but I mean, is it not arbitrary and capricious when you're deciding one of these cases on with one set of criteria and another case with another set of criteria?
what are you referring to?
How you are resolving these tax appeals?
No, well, the decisions at issue, they were all denials, and with
How
respect,
about but the underlying reasons and some of them are settled, right?
well, so this is getting into the sort of the verbiage of the decisions. With respect, they're all the same review. Now, there's also the disparate treatment argument. Now,
Right,
that's a
this-
different that's a different argument. So, and I think that what it's important to note is that so this is a well-worn argument that the petitioner makes, and in their opening brief, they sort of make a lot of sort of very hyperbolic sort of accusations. And it's funny because in page 6 of the brief, in footnote 5, DOF may argue that the commercial overlay in 374 Ashford does not cover 50% of that parcel. The supposed 50% rule is created out of thin air. DOF has never provided any authority that a property with a commercial overlay that covers over 50% of the parcel is excluded from a tax classification of vacant land. So that they are acknowledging that there is a policy. The decisions that they point to are not identical. They involve.
Wasn't there also a claim that some of the applications, that the applications outside of Manhattan were granted, where the applications within Manhattan were denied?
No, so all of the property, so there are about 75 Article 78s that Petitioners Council has brought over the past few years. The way that it works is that the statute 1802 1D essentially says that all vacant land in Manhattan is class 4. So we're talking about outside of Manhattan, and the distinction is that if it's
So there are no class 4s outside of Manhattan?
there are. So in Manhattan, all vacant land is class 4 now. Outside of Manhattan, it's either class 1 or class 4, and the dividing line depends on this phrase, not zoned residential. And since 1989, when the statute was the two class treatment for vacant land was created by the legislature, the consistent policy of the Department of Finance has been if they look at the zoning on the property, and if more than 50% of the property is covered by non-residential zoning, which is manufacturing or commercial, including the commercial overlay, it gets classified as class 4, and if not,
Thank you.
Good morning, Your Honors. May it please the Court. I think it would make sense for me to go right to this disparate treatment argument. What my colleague argued, and it's an argument that they've made recently before the Court of Appeals many times, is that the evidence in the record is different than the evidence here, and that's not true. And I would point the Court to page 510 of the record and to page 584 of the record and pages 160 to 190 of the record. For example, on page 510, it's a property in Queens. It's completely 100% covered by residential zoning, and it has an overlay that covers 55%.
So is that class 4 or class 1?
It's a class 1. They changed it from a class 4 to a class 1. On Crosby Avenue in the Bronx, record number 584, it's residentially zoned, and it's covered by a commercial overlay, 100%. The commercial overlay covers the entire property, and they changed it from a tax class 4 to a tax class 1. So if they say that,
So is it your point that they are not different, that they are treating the same types of property
yes,
differently?
it is our point, and to the extent that they say
There's-
that the
and
evidence,
and that is arbitrary and capricious when they disparately treat.
absolutely. And when they say that there are no, or imply that there are no examples in evidence in the record that don't have an overlay that's over 50%, that is outright false. It's in the record. And I would also like to say, he spoke a lot about this 50% rule. If you look at the statute's determination is that if it's vacant land outside of Manhattan and it has no residential zoning, it's tax class 4. All of these have residential zoning. And I'd also like to mention that whether it's 50, if it's misclassified as tax class 4, whether there's a commercial overlay over 50%, under 50%, or there's no commercial overlay whatsoever. In each of those matters that they corrected, they were correcting an error of law. It was,
So let me ask you this, how do you respond, because counsel, the city again is arguing that the Article 78 is an inappropriate way to resolve this, that you
Well-
should be doing an Article 7 proceeding.
well, what I would say is, first of all, that the way to look at this is not Article 7 versus Article 78. It's Article 7 versus 11206 in the CR. This challenge to this misclassification did not begin with an Article 78. It began under the law, under New York City Code, Administrative Code 11206 and the CER. Once they rendered their
But I mean, I think the city is saying that doesn't matter. Any kind of appeal of a tax classification and this type of appeal has to go through an Article 7 proceeding, right?
No, the only time you could use Article 7 is to appeal a tax commission denial.
Right.
The CPL.
And don't you have a tax commission denial here?
No, we have a CER denial.
Oh, okay.
We have a CER denial. And the CPLR, once you have an administrative denial, except if it's out of the tax commission, the CPLR only allows one way to seek judicial review of that, and that's Article 78. I think if there, unless the panel has other questions, I'm happy to rest on our papers.
Thank you.
Okay, so with respect to the examples that they cited from the record, so this is Exhibit D to the reply affirmation. So they have 7 examples which they say are identical to this situation. 3 of the cases have no commercial overlay at all. They're 100% residentially zoned. So it's not surprising that when presented with an application, the Department of Finance said, oh, you know what, we made an error of description, or we made a clerical error, right? 3 of the examples have an overlay, a commercial overlay of 50% or less. Again, it's not identical. This property under question is 100% commercially zoned. Now, the one,
So are you again positing that these are not the same?
they're not the same.
okay.
Of course, they're not the same. And in fact, the contention that they're all identical is false. The example that they pointed to with the 55% overlay, if you look at the assessment now, it's class 4. It's not class 1. If you look at the
I thought
other,
your friend stated that it was reclassified, that it was originally
if you look at the,
reclassified as a 1.
as of this year, so after this was submitted, if you look at it, it's a class 4.
Did it change after it was submitted?
Every year, the Department of Finance reviews all of the assessments to determine if they conform
The
with the
answer is
policy.
it was changed, it may have been changed, or you don't know?
It was changed. So it was changed because it did not conform with the policy. So again, they're correcting, if it's misdescribed, right? They didn't realize the extent of the overlay, or it wasn't in conformance with the policy. It was a minor mistake or inadvertence. They're correcting applications that are out of conformance with the policy, and they're rejecting ones that are. And with just sort of one last point into the Article 7, counsel is not correct to say that, well, of course, that this is the only way that we could challenge this. The legislature has defined a misclassification ground under Article 7, and while there are no Article 7, the petitioner here didn't even bother to challenge their taxes at their classification at the tax commission, or follow with an Article 7. Now, in the larger
Thank you.
scope,
Thank you both. Hanslick v. UG2. Oh, so cool. You shake hands before. That's really nice.
Well, usually we shake hands after.
Oh, yeah.
Good morning, Your Honors. May it please the court. My name is Jonathan Edelstein. I represent the defendant appellant UG2. This is not a case for summary judgment in favor of the plaintiff. Even if on these facts a jury could credit the theory propounded by their expert, Mr. Gami, which is the only proof of causation they have.
But what did plaintiff's experts say?
Well, what the plaintiff's expert says is that Because these boards were leaned vertically against the wall, they slowly warped along the slat lines over a period of 8 days, creating a trap-like condition.
Did the
which-
plaintiff's expert actually look at the slats?
Well, I would say that he did not, and in
Is
addition,
there any evidence that he, and there are pictures, we looked at the pictures, is there any evidence in the pictures that that actually happened?
no,
Is there any evidence that the panels actually warped or bent?
no, there's no testimony or affidavit or
Does the
affirmation.
plaintiff's experts say that the boards actually warped or bent?
No, he theorized that they did, but our position is his theory was speculative and contrary to the photographic evidence.
But
I
in the
would
complaint-
actually,
In the complaint, the plaintiff also alleges that they, regardless of whether they warped or bent, that they should not have, that they were negligently placed against the wall.
well, even if that's true,
And I want to say the manufacturer also suggested or stated that they should not, that these planks, whatever you want to call them, should not be placed vertically against a wall.
well, even if that's true, negligence and proximate cause are separate elements, Judge. And in order to get summary judgment in favor of the plaintiff has to show all of those elements as a matter of law. And even if this court were to find that there's an issue of fact as to whether these boards should have been stacked another way, there is certainly not evidence as a matter of law that that's what caused the boards to collapse.
Did the plaintiff testify that she touched the boards and then they fell?
The plaintiff, as far as I know, did not testify that she touched the boards.
Said she
She
lightly.
testified that she was counting them.
And as she was counting them, she lightly touched the boards,
Yes,
lightly.
yes.
So could that have been the cause of the boards falling?
Well, that's certainly,
Although they're 85-pound boards,
Right.
I wonder if a light touch could do that. Who
They're
knows?
4x8 wood boards weighing approximately 85 pounds. So a light touch or a heavy touch, how would that, I mean, again, why would they fall? How could they fall? How would her touch, whether it was light or heavy, result in them falling?
well, for one thing, she may have misremembered how light the touch was. For another
But
thing,
even if it's a heavy touch, wouldn't she have to like actually try to move them? And 85 pounds, I mean, that's a lot.
well, for another thing, there are 8 days here that are unaccounted for. This was an open area. It may not have been a heavily trafficked one, but there were admissions that there are no barriers, that FIT employees worked there. There is no way, there is no evidence here, one way or another, about whether any FIT employee or student or other user of the library might have disturbed those boards in a
Does
way
that help
that
you
made
or
them
hurt
less
you?
stable.
Does that help or hurt you in terms of the placement of the planks in this area, where they could be easily moved or touched or caused to fall?
Well, this was the area where UG2 was directed to deliver the boards. I mean, they weren't the ones who made the decision to put the boards in this room. What I would also like to point
Could
out.
they have stacked it on the floor in that room? Because they were stacked when they first received it.
Well, there is the opinion of both Dr. Marletta and Mr. Randall, who's been in the business for 25 years, that would have been a trip hazard. And I would submit as well, I don't think we need to go to the,
Counsel, wouldn't it be problematic for your client that if to stack these boards up against the wall in such a way that a light touch will cause them to topple? Isn't that a trap or some dangerous condition?
well, we don't, well, first of all, according to the plaintiff, a light touch didn't cause them to topple. And second of all, what I would like to point out about the photos is that based on the way the boards fell with the flat side, the wood side down. The wood side was the part that contacted the floor and hit that tube, which would mean that the slat lines were facing the wall. And that this is the opposite of the way the plaintiff's expert illustrated. And this is the opposite of the way the plaintiff's expert theorized that the bending occurred. And if this was, and if a jury finds that to be the case, then that would exclude the plaintiff's theory of how these boards were stacked and how they would have collapsed.
Thank you.
And again,
You have time on rebuttal.
okay.
May it please the court, Andrew Left for the plaintiff respondent. First of all, I'd like to say that Justice Lattin's decision here was extremely thorough and well-written and should be affirmed in its entirety. Second, I would like to say that it's undisputed that the defendants leaned these heavy slat walls upright against the wall because they didn't understand the nature of the flexible material that a
Counsel,
flat...
what's the evidence here on the record that your experts say that these boards actually bent, they bowed, or somehow deformed?
I mean, we produced an affidavit from an architect with a degree from MIT who was the city of New York's chief planner.
I understand that your experts,
He explained...
he put forward a theory, right? But what's the evidence that that theory actually went forward, that's what happened?
If you take a look in the record at page 339, contrary to what my colleague just said, the boards are warped and bent. You can take a look at them, they're lying there.
So if we looked at the photos and we didn't see any warping and benting, even though you are claiming that they are warmed that would raise an issue of fact, right?
I don't think it raises a question of fact,
Well, let me
particularly-
start with that one. Did your expert look at the boards and slats after the accident?
No, they weren't still there by the
So
time
all
of the
what
lawsuit.
your expert's looking at are the photos, right?
He's looking at photos.
So
He's
if I
looked
look at the
online
photos, one second, if I look at the photos and I don't see warping, but he does, doesn't that raise an issue of fact?
It does not.
Oh, how come?
It doesn't raise an
Because
issue of fact.
he's got better eyesight than me?
It doesn't raise an issue of fact because the material that's used here is a flexible material.
Counsel,
that these are
does your
made of.
experts say that the pictures show that they were warped?
Well, they are warped in the
No,
picture.
that's not my question. My question is, does your expert say that?
No. Because when they're lying flat on the ground, they wouldn't still
They
be
straighten out
warped.
again.
Yeah, when they're lying flat on the ground, they have the support of the ground,
So
which
he
is why
didn't
the
look-
manufacturer's instructions...
One second. No one testified that they were warped when they were on this. The plaintiff, your client didn't testify that.
No,
they
I'm
were
just
warped,
looking
right?
at the photograph and
Right,
showing you.
I'm just talking, one second.
Yes.
Your client didn't testify that they were warped, correct?
Correct,
Your expert didn't see them when they were on the side of the leaning, right, on the wall.
Well, it's uncontroverted.
No one, right, and no one else testified that at the time they fell, they were warped, right? There were plenty of people who saw the accident, right? None of
No,
them testified.
no one saw the accident.
Well, saw the boards after the accident.
Correct,
right?
when they were lying on the
And
ground.
no one said anything about them being warped, correct?
Correct. They wouldn't be warped when they were lying flat on the ground.
So the point is, the only evidence or the only statement that they are warped is by your expert who did not see them.
Yeah, and also he didn't say
So,
that they were
yes,
warped. He
so-
just said that they would, the material, the structure of the material degrades over time until they bend, warp, and fall to
How
the
much
ground.
time?
It depends. I mean, in this case, it was approximately 8 days.
But does your expert say that that was the amount of time that process would take?
I think it depends on gravity. It depends on whether other
Does
people
it
have
maybe
touched
depend on the surface on which the floors are placed?
I mean, I don't have a physics degree to say that, but he did explain that by blocking the front of them, they would necessarily move backwards towards the wall in bending and then fall.
Said they can bend over time. Can.
Yes.
Don't we need something?
There's literally
some-
no other
excuse me, counsel,
explanation. Yes.
Don't we need something or someone to state that they actually were bent or warped at some point in time?
No, I think once you know that the
So
materials
it's
were
fine just to
negligent-
have an expert who did not see the planks, did not see the photos of the planks, just to state that they can warp and bend and fall.
Well, it's not fine to only have that. It's also important
So
to
what
know
do we
the-
have that's consistent that corroborates the
They
expert's
failed to
testimony.
follow the manufacturer's own instructions in storing them, which says lay them flat on the
Which is designed to protect the integrity of the material, not to prevent a hazardous condition from forming.
Well, the integrity of the material, meaning that it would flex, bend, and fall if you.
But again, we're left with, we have to assume that they bent or buckled in order to sustain as a matter of law of a finding that there was negligence.
I'm not, no, I don't think so. I think leaning the boards up against the wall without any warnings whatsoever in a manner such that by lightly touching 85-pound boards that their own witness says can't be moved by an individual, I think that's negligent no
The
matter
duty to
what you do.
warn doesn't, that's a separate duty from just whether a reasonable.
Well, it
whether
goes
the
to her
property-
comparative negligence, right?
Right, but
She
first
did
we got to
nothing
get
to
to,
cause
do you
this.
get summary judgment as a matter of law? Because we don't see too many cases where on summary judgment we find a negligent condition existed.
We don't? We see a
don't.
lot.
Okay, so can you cite me to one case in any context?
Any case where a negligent condition existed?
Can you narrow it
We
down?
find as a matter of law? I seem to recall
Yeah, I've
that
had a case in this court with a decision by Judge Latin where gentlemen sprayed water on the ground in January when it was 11 degrees out, which caused an ice rink to form, and the plaintiff slipped and fell and had back surgery.
Okay, well, that's the formation of ice on a public walkway.
Well, this is a condition that they caused by negligently storing the boards up against the wall.
It sounds to me what this really is a sort of a res ipsa case.
It's not res ipsa because there's an expert who's familiar with the materials and explained exactly the nature of the fall.
So if it's warped and it can fall easily, wouldn't a light touch trigger that?
That I don't know, but a light touch in no way can be seen as comparative negligence without any warning whatsoever, and with an expert who also says that the bending and warping would have been not apparent to a layperson, such as a librarian in this case.
So we're basically left with the experts ipstixit, that they bend or they warp, and therefore that must have caused.
Well, I think this is a very explicit.
Well, not only did they bend and they warp, but the bending and the warping would not be apparent to the to an individual.
Right, so in that sense, it's exactly like this piece of paper. When you hold it up, eventually it bends and warps. But then if it winds up flat on the ground, it's not bent or warped in any manner.
Right, but see, I saw that bend and fall. Thank you so much.
Okay.
Your Honor, briefly, to address counsel's argument that the boards wouldn't look warped lying flat. First of all, board is not a piece of paper. A board is rigid. Second of all, there is nothing in their expert's opinion saying that this warping would not have been apparent post-accident. The expert does not give an opinion on these photos one way
Does the
or other.
expert say how long it would take for the boards to start warping? And does the expert say that 8 days is enough?
He's very nonspecific about that. He says over time. And I would invite the
Over
court-
time could mean 3 years or
could
8
mean
days, right?
20 minutes or 3 years. And I would invite the court to look at the illustrations at pages 376 to 77 of the record, which are the expert, these are the plaintiff's expert's illustrations that he made and that he swore to in his report, which shows very obvious and pronounced warping and bending at the point where the board is ready to fall.
Does the expert state that at some point in time it will straighten out? That the boards will straighten out once they hit the floor or once they hit a flat object?
No, that's not in his report at all. That's not in his report at all. That's counsel's ipsy dixit. And I would, just to address what Your Honor, Justice Higgett stated about res ipsa, a res ipsa case requires exclusive control. And we have 8 days that are completely unaccounted for. So if there are no further questions from the court, I would rest on the briefs and argue for a reversal.
Thank you. Thank you both. Wolosky LLP versus Kastenbaum.
Good tradition, Your Honor. We'll start it today. Your Honor, my name is Thomas Fleming. May it please the court, this is our appeal from an IAS court order dismissing 3 portions of our law firm's complaint against its former clients, Fortis Property Group and Fortis's affiliates, in which we seek to recover approximately $1 million in legal fees. This is yet another case arising out of the ill-fated real estate development known as One Seaport, which has already consumed much of the court's time. First, let me address the breach of contract claim, which the court dismissed, which we asserted against Fortis Property Group. Our firm's initial engagement agreement was with a Fortis subsidiary. We later learned that the subsidiary lacked assets. It only owned the fee, which was...
So was there a modification of,
There was indeed modification, Your
what
Honor.
was the modification?
The modification was we agreed to go forward in July 2023 in a series of emails that revised the fee agreement, and the emails were clear, and the complaint should be assumed to be true at this stage, that the new obligor was Fortis Property Group. And the revised fee agreement set up a payment plan for past due, it discounted fees, and it also set up an extended time for payment.
So was Fortis an original signatory to the, was Fortis an original signatory?
No, the original agreement was with its subsidiary, FPG Maiden Lane. The revised fee agreement, we appeared for Fortis in the underlying cases, and we had been representing them as counsel in 3 separate cases in New York Supreme Court for several months. The revised fee agreement obviously was intended to be with Fortis because the subsidiary had nothing to pay us, and the email exchange is clear that we wrote, we accept Fortis's payment as outlined to satisfy the bills, and we also wrote, any failure by Fortis to honor its commitments will likely be fatal to our relationship.
So that was sufficient to now bind Fortis?
That's what the complaint alleges, which should be assumed to be true at this stage. And certainly, it's clear on the language of what we exchanged that we were looking to Fortis for payment. Fortis was the entity that, in fact, had been paying us, and we were dealing with the general counsel for Fortis, Michael Regan, who we exchanged these emails. It really made no sense for us to go forward with an obligation from the subsidiary that had nothing. They were subject to foreclosure, and their sole asset was the fee, which was subject to a $100+ million mortgage.
So how is, you also have a claim for fraud. How
Yes,
is
Your
that
Honor.
separate from the breach of contract claim?
I knew the court would ask me this question.
I look forward to your response.
Well, the fraud claim, Your Honor, is asserted against Louis Kestenbaum. And this case brings up an oft-repeated set of issues where the court is called...
What damages are you seeking against Mr. Kessenbaum?
I'm seeking our...
Contract damages, right? Not a penny more, not a penny less.
Correct, Your
Are
Honor.
the facts all the same as I breached the contract?
No, the facts
Have
are
you
different, Your
alleged
Honor.
any other facts other than I breached the contract, I knew I was going to breach the contract, and then I breached it?
Yes, we have, Your Honor.
What?
Well, first, Mr. Kestenbaum is not a party to the contract.
Okay.
So it is separate.
Right.
And what the case brings up is the issue between the cases where the court has ruled that an insincere promise of future performance of a contract is insufficient versus cases holding that a preconceived...
Did he have an
intent not-
obligation to perform?
He did not, Your Honor.
So,
but
okay, if he says, so where is this, where are you coming out with this duty?
No,
He has no duty to pay anything. If he tells you, I'm going to jump 100 feet in the sky, and he doesn't jump in 100 feet in the sky, do you have a fraud claim because he knew at the time that he wasn't going to jump?
because he knew at the time he wasn't paying, and he knew his
He
entities
had no
weren't
obligation to pay, correct? At the time you are alleging that he said it?
The entities had the obligation, Your Honor. The contract was with the entities.
Again, did
But
he
was the one who made-
personally have an obligation to pay at the time you say he fraudulently told you that that they were going to be
He
paid?
did not, Your Honor.
So how are you pleading this claim against him?
I would offer the cases that we're talking about, the preconceived intent versus the insincere promise. it really comes down to contracts to sell something like the Brooklyn Bridge.
Exactly, and he has no contractual duty to do anything.
if
He's
someone-
not a party to any of those contracts.
No, but if someone uses the corporate form to sign a contract,
That's a different thing. That's a Pearson claim. We're talking about the fraud claim. He has no contractual duty, and you are alleging that he insincerely claimed that he was going to perform a non-existent contractual duty, and therefore I should plead a claim of fraud against him, right?
that is what I'm alleging.
Okay.
But you've anticipated my final point, and I'll rest at this point since my time is up, which is we do have a veil piercing claim, which the court also dismissed. And veil piercing goes beyond fraud. It includes inequitable conduct and malfeasance, and certainly we have alleged domination and control.
Well, then, with the piercing claim, though, how did you allege that there was any type of abuse of any corporate power on his part?
Because the
Or
entities...
of corporate form, rather.
Because the entities didn't have the ability to pay us. So we were contracting with entities that were
So it's
insolvent.
kind of, to some extent, it is a circular argument, but you do have time on rebuttal. Thank you.
Thank you, Your Honor.
You have a microphone there. Thank you.
Good morning, Your Honors. Jesse Capel for the respondent defendants. I think as the court has
So why was there not a modification?
If there was a modification, it was with FPG Maiden Lane, the originally contracting entity. As Your Honor noted in questioning of co-counsel, or of my esteemed adversary, Mr. Fleming, the Fortis property was not a signatory to the original agreement, and there's nothing alleged in the complaint that Fortis itself was obligated under the modification agreement.
What about the emails? There's an email chain with Fortis wherein they agreed that they they agreed to a payment plan.
The allegation is that after Fortis proposed the plan, Olshan said we accepted on behalf of Fortis, but there was never any meeting of the minds or anything on behalf of Fortis that's alleged in the complaint to signify its intent to be bound under a revised fee agreement.
Well, didn't Regan say Fortis's principal, Louis Kassenbaum, so that communication connected Fortis and Kassenbaum to the payment, which would be a modification of the engagement letter?
Mr. Regan was the initial signator to the original fee agreement as counsel for FPG Maiden Lane, so it's the same person. It was Olshan stated after the proposed revised agreement had been made.
What do you say to counsel's argument that Fortis was substituted now because Maiden Lane didn't have the funds to pay?
For FPG Maiden Lane was always a client of Olshan, so the Fortis may have been added, but the issue is that the written fee agreement only involved.
Counsel, there's a July 14, 2023 email stating that Olshan accepted Fortis's payment as outlined to fully satisfy the bill through April 2023, right? Did you write back and say, not Fortis, somebody else?
Well, I was just quoting what was alleged.
Pre-answer motion to dismiss, right?
Yes, pre-answer, yes.
So that email says Fortis's payment. This is the revised schedule, and it doesn't say FP whatever, Maiden. It says Fortis's payment. And there's nothing in response by your client saying, not Fortis, somebody else.
Well, the complaint only alleges what the email said, which is that we accept your payment
Exactly.
on
So
behalf.
the question becomes, doesn't that raise an inference that there was a modification to the fee agreement in which Fortis agreed to be responsible for the bill?
Well, let me just also point out that the claim was also dismissed because of language in the original fee agreement which I can read from. And this was, again, with FPG, Maiden Lane, and Olshan. The engagement letter specifically states, unless specifically stated otherwise in the attached letter, our representation of you does not extend to any of your affiliates, and we do not assume any duties with respect to such affiliates, including shareholders, partners, members, parent entities, subsidiaries, sister entities, or any other entities in which you own an interest, or any directors, managers, officers, or employees of you or any of the foregoing. And then it also it says that there's a formal modification clause in the terms of the engagement. It says, no alteration, modification, or variation of the terms of our engagement will be effective unless set forth in a writing executed on behalf of the firm by one of its partners. There was no such writing and there was no such execution. It's not even alleged that there was such.
Well, isn't there an email signed by counsel that we have held more than once in the past satisfies the written modification rule?
In this case, the emails
And the
were.
response makes clear that it's Fortis who's now responsible for it, and there is nothing back saying, again, this is a pre-answer motion to dismiss, right? I mean, it may turn out that during discovery that neither party intended that, but this is what the allegation is. We have to assume is true.
Sorry, I didn't mean to interrupt you.
No.
The other thing I would just say is that this was, yes, it was a pre-answer motion to dismiss, but there was also documentary evidence that we submitted that the underlying court, Justice Frank, found conclusively refuted the breach of contract claim against Fortis.
Thank you.
Thank you.
Your Honor, I think Justice Scarpula hit the nail on the head by noting this is a pre-answer motion to dismiss. The complaint assumed to be true. There will be discovery, and there can be a debate about what actually was intended, but the pleading certainly alleges and provides, the actual written support in its text that there was an agreement to have a new obligor come on board. The fact that they're contending that the sole obligor is FPG Maiden Lane, the asset judgment-proof subsidiary, if anything, underscores the propriety of a veil-piercing claim here. We don't know what case we're going to be having, but if they're going to claim that our firm agreed to go forward with an entity that had absolutely no assets and no ability to pay, Mr. Kestenbaum was in control of that, and that, I would tell you, is malfeasance and inequity, and there's actual First Department case law. We cite the Lederer versus King case where an attorney did pierce the corporate veil to recover fees precisely because the entity had no assets to pay them. If the court has any further questions, I'd be glad to answer them.
Thank you.
Thank you, Your Honor.
Jones v. River Park Residences. Yes.
Good morning, and may it please the court. Denise Rubin for Plaintiff Kishana Jones. The two most basic foundational aspects of deciding a summary judgment motion are that the court does not make determinations of credibility and that the court identifies material issues of fact, and that's it. Once that happens, that material issues of fact are found, summary judgment is denied. That didn't happen here. Here, the court, going through in a very detailed fashion the record before it, found that Ms. Jones's testimony that she had put a foot in, that she had not turned on the water before getting in the bathtub, that she didn't feel wetness on her feet because she immediately
What the court stated was it was your client's inability to state the reason for her fall, how she actually fell, and whether or not the proximate cause of that fall was the water as a result of a leak in the tub.
Yes, Judge, but that was not the case. She actually testified afterwards that when she woke up, her feet and her legs were wet with water.
Right, but she had no recollection of exactly how she fell. What happened?
She put her foot in the bathtub and went immediately down. There was water in the bathtub, which Mr. Lindsay.
Well, did she say there was water in the bathtub?
No, but Mr. Lindsay, well, she found it there after she was woken up, and Mr. Lindsay
Did she say that?
testified.
I think she didn't testify to that, right? She put in an affidavit
Right.
on summary judgment for the first time, she said, and I understand your point is, well, nobody asked her. So for the first time, now, she said on her affidavit, not in any of her deposition testimony. In her deposition testimony, she said, I put a foot in, I fell, the next thing I know, I'm in the ambulance, or I'm on the floor getting ready to get into the ambulance.
Right, and I know, as my colleague just stated, she was never asked during her deposition whether or not whether there was wetness or anything like that when she woke up.
Correct, and therefore her affidavit offered on the motion is not a feigned issue of fact. It's addressing an issue that she was never asked about during her deposition. But Mr. Lindsay also testified. He said, I saw there was leaking and water in that tub in the afternoon before she ever went into the bathroom to take that shower or bath. He saw water there. He didn't think to tell her about it because it had been going on and off for so long that it was just accepted between them. There's going to be
On
leaks.
that point, counsel, the fact that, let's assume that there was water in the bathtub, is that fact alone sufficient to show a dangerous condition?
If she slipped and fell and woke up with wet legs and feet, yes, I believe it is. I don't think that constitutes speculative testimony. She was not having a dizzy spell before she fell. She clearly testified to that. She was not lightheaded or having any other health issue. She gathered the stuff to take a shower and shave. She starts to step into the bathtub without first turning on water. The next thing she knows, she's flat out and unconscious.
So wait, is
in the
it
tub.
is your argument anytime there's water on the bottom of the bathtub, that's a negligent condition?
Well,
What if somebody took a shower 10 minutes before? I live in a house with a lot of people in one bathroom, right?
Well, not, I know,
Take
but
showers after each other, the bathtub could be wet.
by definition, isn't there water in the bathroom, in the tub, from the shower? That's what I'm not understanding from your argument.
no.
It's been dripping, isn't it foreseeable?
Well, that goes to the defendant's open and obvious, because you just stated that the boyfriend, that her fiance, he's referred to as her fiance, I don't know.
Correct.
That Mr. Lindsay, that he saw the water in the tub that afternoon and didn't tell her because, he figured, why tell her? Because she knows. So again, does this not go to her knowledge of it, and therefore she should look in the tub before she puts her foot in?
She testified that the water was light, that she did not see it. She looked in as she's stepping in. She didn't notice water there. And she said later that it didn't cover the entire bottom of the bathtub. I think he also testified to this, that it was just in the area where the faucet is dripping at that end of the bathtub.
So she puts her foot in by the faucet?
Well, I don't know what the.
So she's getting in the
layout of
tub
that
by
bathroom is.
the faucet, is that?
Pardon?
She's getting in the tub, she's putting her foot
She starts to step in, yes.
by where the faucet is, in the
She
tub.
didn't testify one way or the other as
Ah.
to where the faucet was. She testified that I started to step in, and the next thing
So she steps in with her foot in it, but she's found with her legs over the tub, right?
That's what he testified.
So she's found, so her body is in the tub, yes, and then her feet are over the side of the tub. So that means when she put her foot in the tub, she did a complete 180 and falls, and then her feet come over the tub, the side of the tub?
We don't know exactly how that happened. He obviously did not see her go down. But it is possible that in falling, the feet come up. If you can picture somebody slipping on ice, your feet go up and you're down.
You twirl around.
Not necessarily,
Well-
but she may have not been completely unconscious. She may have been kind of like dazed and moving
Well,
around.
she said that she was, though, right?
Pardon?
She said that she lost consciousness.
She did. And she also he testified. Initially, he said, well, she didn't tell me what happened because she was unconscious. But then later in his deposition, he says, but after she calmed down, because she had been somewhat hysterical when she first woke up on the floor, she was bleeding. She'd broken both her maxilla and her mandible. She was in a lot of pain and was missing a bunch of teeth. But he said later, when we had her calm down in the ER, she said to me, I slipped. I fell right down. So she did realize what it was. She did tell him, and his testimony has not been rebutted by anyone.
Thank you.
Good morning, may it please the court. Rachel Smith for the respondents. I don't even remember the actual fall. When I stepped in the shower, that's all I remember. I don't remember anything else. I'm assuming that is the testimony as to how this accident allegedly occurred. By Ms. Jones's own statements, we cannot reconcile how this alleged accident happened without engaging in speculation, which I think is
No,
what
that's completely not correct. There's testimony from somebody who ran in after the accident. We have never held that that the person's inability to recall the accident with other evidence that shows how the accident occurs means summary judgment. Her fiance said, as soon as she fell, I ran in. There was wet, and she was on the floor. That is circumstantial evidence, sufficient at least to raise an issue of fact that she fell because of water in the tub, right?
I don't disagree that the court's holding says that you can take logical inferences when there's not direct evidence as to how an accident occurred. And in this instance, the logical inferences do not help Ms. Jones's case in establishing proximate cause and require us to engage in even more speculation to reach a conclusion on that point. And
why would it be speculative if her fiance comes in, she's wet, the tub is wet, and she fell?
well, so
Why is that speculative? That's he saw what happened, right?
So the sworn testimony at the deposition did not say that she was wet. He
Wasn't
recalls.
asked.
I'm sorry?
She was not asked in her deposition.
She was asked what she remembered after the accident, and her exact statement was, all I remember was being in pain. I don't remember feeling wetness. That then
She said, I don't remember feeling wetness after the accident?
I recall her saying that she
Show me
stepped in
where,
the
because
shower.
I looked, I did not see her saying anything directly contradictory. If you're,
Okay.
tell me where.
Well, I recall that she was asked what she remembered, and she said she was in pain. Now, in that point, as the court knows, there's tons of case law about affidavits that come up on summary judgment, and this lower court did consider her affidavit and still found it to be unpersuasive on the issue of proximate cause. Mr. Lindsay's testimony, as Your Honor correctly pointed out, does not help us give a logical inference that she fell because she slipped on a dripping faucet. His testimony that her feet were hanging outside the tub begs the question as to whether she stepped in at all. Her history of having dizziness and lightheadedness from a condition in her ear begs the question.
She denied that that condition affected her that day, correct?
She also denied that she didn't see any dripping in the faucet.
That's not my question. My question was, did she deny that that condition affected her that day?
She did not have the condition that day, but she rated it at like a 7 or 8 for the month leading into that. And so if we're going to trust what she denied on that day, let's trust her testimony that she denied seeing.
Why is this, all I hear from this argument is fact-finding, fact-finding, fact-finding. She must have, from this evidence, she could have slipped and fell. Why not just put it all before the jury and let the jury decide?
Yeah, it's your motion for summary judgment. So again, if there are issues of fact, then these are issues that the jury would determine.
Because a jury cannot reach that conclusion without doing the same kind of assuming that Ms. Jones admitted
I
they
have
did.
given, I think every
And-
judge on this court has given the circumstantial evidence charge 1,000,000 times. Certainly, the jury could find under the circumstantial evidence presented that that was the cause of her fall.
And again, I would submit that the circumstantial evidence in this case does not establish a logical inference that she slipped because of a drip over the drain of her bathtub. It wasn't dripping from the shower head. It wasn't, there's not an allegation that this bathtub
Do
was.
you address her allegations that there was this constant dripping, that in fact, there was an attempt to repair it 2 weeks before that failed and it continued to drip?
I do address that allegation. Well, we've submitted work orders and testimony from our super that there was no complaint about the drip before this, and that establishes a lack of notice. But we don't even have to get to whether the duty was breached because we don't even know that that caused her to fall. by any
Didn't
logical
she and
inference.
her companion both testify that they had made complaints?
They testified that they had made complaints, but they also testified they made complaints about other things. There's work orders for those other things. There's no work order for this complaint.
So we
I'll
have
also,
them, we have her and her fiance saying they made complaints. We had your people saying, I think at best that they don't know. Isn't that an issue of fact?
no, their testimony was there were no issues of complaints, that there was nothing in the record to support that conclusion that they had complained. But I think, again, we don't even have to reach the issue of notice because we do not even know, there is no direct evidence or logical inferences from the direct or from circumstantial evidence to support a conclusion of a breach to begin with. And I just want to, before I finish, touch on the point of the fact that this is an open and obvious condition. As the court questioned my adversary earlier, a wet bathtub
Well,
is...
an open and obvious condition, that doesn't relieve you of your obligation to maintain the premises in a reasonably safe condition, correct?
A private area that is leased by the tenant is something that is entirely within her control. I don't have my client doesn't have an
You were supposed
obligation.
to fix the leak yourself?
If she establishes notice, which she didn't, and if she establishes that was the cause of her fall, which she cannot do by her
Well,
testimony.
again, there was testimony that the leak had been fixed 2 weeks before, right?
I believe that the super said that they had been in there doing other work and that there was, I'll also represent for the court too, that the testimony about repairs shows that after this accident, they did go in and do the work, which begs the question too, that she did not complain prior to this, but for the sake of the...
Super testified, do you know she made complaints prior to the accident? No. So I don't know how you get around that.
No, she did not make complaints.
That's what he testified to.
No,
I
she
don't know
didn't
what
make
that
complaints.
means. No.
I
he
think you
didn't
get
know. The question is, do you know whether she made complaints? The answer was no. I don't know whether she made complaints.
Does it, I don't know that the question was direct.
I'm only
and
reading
clarifying
what the deposition testimony
Fair enough,
says.
but I would present to the court that as you all question my adversary, a wet bathtub, particularly a drip over the drain, it does not mean that she fell in the area where this drip even occurred, because who steps in over the drain of a bathtub? Also, on top of that, we're not talking about an allegation about a slope issue in the bathtub. We're not talking about an issue with the surface. And a wet bathtub is not an inherently dangerous condition. And that being said,
If it's caused by a continual leak that the landlord has not repaired or has negligently repaired. Thank you so much.
thank you.
I would note that Mr. Leckram's testimony, Mr. Leckram is the superintendent.
Counsel, can you lower the mic a little bit, please?
Sorry. Mr. Leckram's testimony, when he was asked, do you know if they made complaints? And he said, no, i.e. no, I don't know. He also testified that if there had been, as they testified, multiple complaints, that if those complaints were about the same issue, here, a leaking bathroom faucet, there would only be one entry in the computer system for such a complaint. No matter how many times they complained, the computer system would treat it as the same complaint and not make a multiple showing. So even as to whatever they produced, that testimony supports Mr. Lindsay and Ms. Jones's testimony. We tried to get the written copies of our complaints. They told us they couldn't give it to us. We don't know why. They just wouldn't give it to us. That, again, supports their testimony, because if there's only one entry in the computer, there's nothing else to give them. But also, I would add that, as the court has pointed out, these are fact issues again and again and again. It is not enough to say, well, he said this, because if he said this, but they said that, that's a material question of fact on these issues. Whether they had complained, whether there had been notice, whether a proper repair had been done. They produced no logs of repairs, and he was asked, do you keep a record when you do repairs? He says, well, no, I don't write things down when I do the repair. So all of this goes to say that...
Is your argument of negligence that water in the tub, with unexpected water in the tub, is a negligent condition? Because obviously water in the tub it in and of
No.
itself can't
Yeah.
be negligence, right?
Well,
So
as-
what is your claim of negligence?
As Your Honor pointed out earlier, if you have a lot of people using a bathtub, it's reasonable to assume somebody is going to wash there and it's going to be wet. But they expressly testified, neither of us used the bathtub earlier today. And
So it's the unexpected water in the
It was
tub.
unexpected, but only to the degree that neither of them had showered or used the bathtub that day. It was somewhat expected only in that we've got this ongoing problem with a leaky faucet, and no
Well,
matter
that's your
how many
comparative
times-
negligence,
I'm sorry?
right? though? That would be comparative negligence, right? If they expected it to be there but didn't look, all right?
Yeah, I don't think,
Okay.
I don't think they expected it because she said it had been repaired 2 weeks earlier and we didn't, but it did just start again, apparently, because there it was leaking.
Thank you, thank you both.
Thank you.
Molina v. Mount Sinai Morningside.
Good morning, Your Honours. May it please the Court, Neil McKilvoy on behalf of Plaintiff Appellant. Your Honours, it's undisputed I should say here, that a court may not convert motion to dismiss into a motion for summary judgment without advance notice to the parties.
Yeah, so was there any notice to the parties that the court was going to convert this into a motion for summary judgment?
No, Your Honour, and I think the decision itself makes that clear. The decision doesn't purport...
And neither side requested it, is that correct?
Excuse me?
Neither side requested?
Neither side requested it. It isn't a pure issue of law. Statute of limitations issues are mixed issues of law and fact. And also, neither party was deliberately charting a summary judgment course. I would say in terms of defendants, they had a very easy way to chart a summary judgment course, make a motion for summary judgment. I mean, what's quite unusual here is that most of these cases, I think it's fair to say, involve pre-answer motions to dismiss. What's interesting here is that it's a post-answer motion to dismiss. So they made a motion they're not entitled to make in the first place. Had they been charting a summary judgment course, you make a motion for summary judgment. In terms of plaintiff, appellant, obviously over and over again within the opposition papers, it is pointed out that there has been no discovery. There are incomplete medical records. In terms of the specific records, Dr. Africa's records, we know there are records that weren't provided.
So is that your point, that I could have, I mean, obviously, the way it looks now is it's, the statute of limitation was blown, but the question is your point that I need to look at all of the records to determine whether there was more information that I could have put up with respect to my continuous treatment claim?
Yes, Your Honour. And well, let me say this. Because it was a motion to dismiss, plaintiff here was entitled to rely on his complaint. The allegations in his complaint, what's in his bill of particulars, which was that there was continuous treatment all the way through June.
Did the defendant put all the documentary evidence in?
No. What's missing here are Dr. Africa's records.
And you're saying that that may have shown continuous treatment?
Indeed, and we know they exist for this reason, because in the records that were provided, it's page 975 of the record, there's an indication there of medications that were prescribed by Dr. Africa back in 2016. We don't have the records of that particular visit where he did in fact prescribe the medications. He's referred all the way through for the next 2 years as the primary care physician. So we know those records are outstanding. Obviously, we don't know how far they extend, but we're, in terms of plaintiff, is entitled to rely on the allegation in the complaint to say that the treatment continued through June of 2019.
The treatment of his head?
The treatment of his, so when he's discharged...
Oh, you're talking about it as his internist, right? And continuous treatment would only go to the mass on his head, right?
Agreed, but...
So what does the plaintiff say about the treatment to the mass on his head?
This is what plaintiff says. And again, in terms of the records that are before the court, I think it's page 539 of the record, When he's discharged from Mount Sinai in June of 2018, he's instructed in terms of his discharge to follow up with Dr. Africa about the tumor in his head. So
And he says he did, and there are records that would show that?
well, that's the allegation. And again, obviously, the difficulty here is that you have a decedent, you have not only that, but a decedent before he passed that was suffering from dementia. So obviously, in terms of putting together the full picture here.
So, Counsel, could you address, I'm looking at the complaint. Can you tell me how in the complaint you state a cause of action for the emotional distress?
Well, Judge, let me pull the complaint. The theory essentially is this in terms of the decedent. It may well be that cause of action would be, I think it is likely to be subsumed within the medical malpractice one. But the theory is this, that what has to be shown is that he was, by reason of the negligence, he was placed either in physical danger or in fear for his safety. What the record shows is that because of the tumor and because of it not being properly diagnosed, he's falling repeatedly. So I think there is the physical danger aspect. Now, there's probably also physical injury, which would subsume it within the medical malpractice cause of action. And there's also, again, subject to what I said in terms of him suffering from dementia, but I think nonetheless, he has been placed in fear of falling. So that's essentially the theory. In terms of the complaint, I don't know how well articulated it is within certainly the portion of the complaint where the cause of action is set forth. Obviously, it's set forth, I think, if memory serves, it's set forth in a single cause of action both as to the decedent and as to the plaintiff.
Right.
There's no dispute that the plaintiff here doesn't have a cause of action for that, but I think decedent would have one, and I suppose the question would be, again, most unlikely in circumstances where there is no physical injury, where it's a purely emotional or mental harm. I think the cause of action is nonetheless stated because, again, you have somebody, because of the tumor, whose physical safety has been compromised and is also, I think it's fair to say, or fair to infer that he was in fear of falling during that time.
Thank you.
Thank you, Your Honours.
You have time on rebuttal.
Thank you.
Good morning, Your Honors. Nicholas, may it please the Court. Nicholas Tam from Shab Omni Citronus, Brad appearing on behalf of the
So,
respondent.
Counsel, it's clear that there was no notice to the parties concerning the conversion to a motion for summary judgment. Parties did not consent to the same. So, why should it proceed?
Because the statute of limitations issue is a pure issue of law. There's case law cited in the brief. It's a calculation based upon the dates pleaded in the complaint and the records provided by the defendant. In that case, the court can convert without notice.
You put in all the medical records that your clients had with respect to the decedent?
We put in all the medical records from Mount Sinai, and it was certified by the hospital.
How about the doctor?
So in the pleadings,
Pretty straightforward. Did you put in the doctor's records?
the doctor's records are subsumed in the Mount Sinai records because
And the doctor put in an affidavit that says, these are all my records as to this guy.
he did not put in an
Okay, good. So we don't know whether he has his own records, right? Sometimes doctors keep their own records, sometimes they keep them at the hospital. So he didn't put in his records. The hospital put in the records, right?
Yes.
So the plaintiff says that his records are going to show continuous treatment.
So I would address that in two ways. First of all, I think the plaintiff is constrained by his pleadings because on one hand, he claims treatment in July and October 2019. We asked the plaintiff for any of these records. They never respond to us with records from June or October of 2019. Also, it doesn't make sense because he was in Philadelphia treating at Temple Health. Second of all,
well, because he doesn't have the records, right? Most people don't have their own medical records. Let's be realistic. So you say to the plaintiff, give me every record that you have about medical treatment. Scarpula, appellate division judge, couldn't do that. How is this man going to do that?
because through his attorney can obtain these records. And
That's exactly what they want to do. They want a shot to look at the records and see, right?
presumably this case would have been vetted by the attorneys and the doctor in a medical malpractice action to obtain a certificate of merit to say that this person had brain cancer, to allege the things that he did in his pleadings. So where in the
There's
record?
no expert that's going to, no medical expert has to be testifying about the statute of limitations.
Correct.
It all depends on the documents. And my question to you is, are all the treating documents records in the record now? And your answer to me is no, correct?
That's not correct.
So the plaintiff's primary, are all his personal records in the record right now?
That's not
Well,
part
you
of the-
might not think it's
Correct.
relevant.
Yes.
I'm asking you that question.
Correct.
Are
It's
they?
It's not part of the record, but
Okay.
as pleaded, he indicates the dates of treatment and the nature of treatment. He doesn't say anything after that. But I think the more important point here really is that he wasn't treated for head complaints or anything in connection with his meningioma, which is a benign tumor. It's
Maybe
common.
just for my own edification, which exception or exceptions under 4 seasons are you relying on to get around the lack of notice for the conversion?
That it's a pure issue of law, that statute of limitations calculations are a pure issue of law, and that it's within the court's discretion that when it's a pure issue of law, under this court's case in Camco, statute of limitations is a pure issue of law.
But it is a question of law, statute of limitations, but it's informed by whatever the underlying facts are, right? We have to know the facts in order to know whether a claim is time barred.
Correct, and we laid bare the proof by providing the records, asking the plaintiff for any records indicating the word cancer or malignancy. That's absent in the record. So he was never treated for cancer by the defendants in this case, and there certainly is no course of treatment that was started because the plaintiff admits that he never knew he had a tumor, and certainly wasn't continuous because Dr. Africa, even if these records existed, didn't start a course of treatment. So I submit to this court that none of the elements of the continuous treatment told the statute of limitations. Thank you.
Thank you.
Your Honors, I'm not going to dwell for too long. I'll just make one point. Opposing counsel had stated there that there's no indication.
Let me ask you, what is your good faith basis of arguing or pleading that there was continuous treatment?
The good faith basis is that when discharged in June of 2019, he was instructed to follow up with Dr. Africa, who was his primary care physician. That's the good faith basis. I will say.
And you think that there was care, you just don't know about?
We don't know, Your Honor.
Okay.
I mean, and what I would say, I do think, though, that the likelihood is that the stronger argument ultimately will be, once the facts are in, will be the Laverne's Law argument. And I would point, even in the records that we have, I think it's page 555, the scan at that time, the CT scan, states that the meningioma is probably benign unless history of malignancy. At that same time, so I believe it's page 522, when he's admitted at that time to Mount Sinai, what is stated there in terms of family history is that his daughter had just been diagnosed with brain cancer. When he's discharged at that time, I think this is page 539.
Shouldn't he have known at that period of time?
Well,
so that doesn't really help you out at all.
No,
I think
but
that dooms your claim.
Well, no, well, again, I mean, it'll ultimately be an issue of fact. If the point here will be that if the doctors didn't know, how is a man in his late, I think he's either 79 or 80 at this point in time, supposed to know that?
Well, he knows his daughter has brain cancer right then, right?
Well, we don't. Again, Your Honor, I mean, it's unclear. And again, I'm not trying to.
The bottom line is that your argument is that it involves questions of fact.
Absolutely, Your Honor. These are the unavoidable issues of fact.
Thank you. Thank you
very
both.
much.
Greenway Muse v. Liberty Insurance.
Sorry. I'm spreading, okay.
Good morning. May it please the court. My name is Timothy Keene. I represent the Appellant Federal Insurance Company in this case. The court's already indicated familiarity with most of
Yeah, so how has this changed from Greenway 1, 2, and 3? This is now Greenway 4. So how has anything changed?
Great question.
Thank you.
Greenways 1, 2, and 3, this court said reasonably clearly, we'll look at what it said exactly, but there was at least a colorable right for federal to recover. So in those cases, Seneca was the appellant. In this case, not only is this different from Greenway 1, 2, and 3, the lower court, Judge Shellman, when he sat on the lower court, and Judge Angoran previously in this case, have every time said that federal should prevail. Truth be told, I really wanted to ask for 4 minutes for reply, 1 minute for addressing the court. I'm really interested in answering any questions the court
do that?
has. Your Honor?
Do you want to do that? You can do
I'm
that.
happy to do that. Thank you.
Okay, go ahead. Yes, sir.
Good morning. May it please the court, Barry Soretsky for Seneca Insurance Company.
Could you move the mic down a little bit, please?
Oh, yes, sorry. In the first
So
instance,
same question. This is Greenway 4. What is different from 1, 2, and 3?
what is different is the decision and order appealed from by Justice Angoran, which is the only decision based upon a complete record which shows, as a matter of law, that Federal Insurance Company has no claim against Seneca. And
Was that decided in 1, 2, and 3?
Sorry?
Was that issue decided by this court in 1, 2, and 3?
oh, to the contrary, the opposite. This court's opinion, what we refer to as the 2020 Appellate Division decision, merely holds that Federal's claim is colorable, meaning that obviously it hasn't been determined yet. It also holds that each party's entitlement, if any, to the fund paid by the insurers, LIUI and INIC.
So I'm sorry, so how has Seneca shown that, as a matter of law, that Federal waived its subrogation rights?
Well, that's a different issue, which I'm happy to address. But I just want to point out very, very briefly that a year later, this court, in what we call Appellate Division Order Number 2, says the interpleader actions is a proper vehicle for the resolution of Seneca's and Federal's entitlement to the funds paid by the UAD insurers, that's LIU and INIC. Federal's cross claims could be determined within the interpleader actions. That's precisely what happened here. On a full record, before the motion court, the court determined, based upon undisputed facts and as a matter of law, that Federal has no claim against Seneca. And I'll get to the waiver in a moment, I promise.
You have 13
Your Honor.
seconds.
The reason for that is that Federal's claim is posited entirely on its payment of $2.3 million toward the settlement of the U lawsuit. And Federal claims that by reason of that payment, it becomes subrogated to Greenway's rights. But the law is clear, uniform, and unequivocal that an insurer's subrogation rights are totally dependent on the insured's rights. Here, Greenway has no claim against Seneca. Seneca was Greenway's primary insurer and paid the totality of its primary limit, the $1 million, to settle the claims against Greenway, the insured of both Federal and Seneca.
Thank you.
To, okay. If there are no other questions, then we're happy to rely on our brief. Thank you very much.
Thank you.
Thank you, Your Honors. So we're relying on the briefs too, of course, 38 pages, it's all there. But Justice Weber has kind of hit the nail on the head. It's number one, in which the very same issue that is being addressed here today was addressed. The question, and it was the very same facts. There's no greater factual exposition now than there was 5 years ago. The very same facts. The lower court, Justice Shellman, and this court said there's no waiver of federal subrogation right. Unless the court has questions, I'm happy to rest on the briefs.
Thank you. Thank you both.
Thank you.
People v. Angel Soto.
Good afternoon. I'm
Just one second. Yes.
sorry. I'm Catherine Martone on behalf of Mr. Soto. The hearing court here erred in denying him the opportunity to participate in the judicial diversion program under Criminal Procedure Law, Section 216.
Counsel, let's assume that that's true for the moment. The remedy you're asking for is dismissal of the indictment.
Right. I don't in these cases, and there have been a few now, I'm trying to understand. The remedy that you are asking for, as my colleague just stated, is dismissal of an indictment because a defendant was, you're arguing, not allowed to enter a diversion program. However, the defendant, and in this case, the defendant was sentenced to 5 years probation?
Yes.
Yes, and that was in 2018, right? Yes. So the defendant has completed the probationary period.
Yes.
The case is, for all intents and purposes, closed. So now you're asking that we dismiss the indictment, vacate the plea and sentence, dismiss the indictment because there was no diversion?
Yes, because that is the only remedy now that can, that's the only relief now that can remedy the hearing court's error.
Well, there's another remedy, right? We could vacate the plea and sentence and remand for further proceedings. Why not do that? Why not reinstate the indictment?
Because the remand would serve no purpose. Mr. Soto has fully discharged his sentence and he has completed drug treatment. Under CPL 216.05, in the circumstance where the defendant successfully completes diversion, then the court can dismiss, vacate the felony plea because that's entered prior to his entry to the program. So where the defendant succeeds, the court can vacate his felony conviction and dismiss the indictment.
Well,
normally it would be a replete, right? It would be that the diversion would be you complete the program and we're gonna vacate the felony plea and you're gonna replead to a misdemeanor.
That's not normally, Judge. That's not the case at all.
Okay, so in all the cases that I dealt with, that's what was done.
Well,
but okay, if you're stating that's not normal, that's fine.
That's
So you're
one-
gonna that's one possible relief. But now, this is a 2017 indictment, right? He was sentenced in 2018. We are now 2025.
Yes.
So again, now we're going to just vacate, we're going to dismiss the indictment.
Yes, Judge, because the vacatur of the felony conviction is what the legislature intended.
Well, how do you may I ask you, how do you distinguish People versus Kirk?
Well, there, Judge, The court,
We said that's not an appropriate, this is not a small little,
no, I understand
right?
that this is.
How is this? This is exactly the same type of
But the court
case.
there, I'm sorry to interrupt you, Your
That's
Honor.
all right. No, no.
But the court there plainly indicated that that relief would be appropriate on the right facts. And what I'm saying here is we have very.
I think what the court there said was that this was not one of those types of cases where you would just dismiss the indictment as a remedy.
On the facts there, but no.
Aren't the facts pretty much the same as here?
No, Judge, because here, Mr. Soto did everything right. This is a case where he recognized right after his arrest that he had a problem. He voluntarily enrolled in drug treatment. He was.
Well, there was, there was a hearing.
One more thing to say, Judge.
Yeah, so I'm going to talk first, okay?
Okay.
So here, there was an actual hearing, right, where there were witnesses presented. I think his daughter testified, he testified. His testimony was a little inconsistent in terms of whether he had a problem, a drug addiction problem, whether he didn't have a drug addiction problem. His daughter testified to the same. There was also testimony, I think, from the representatives from the program. So, there seems to have been an inquiry by the court and then a determination based upon that inquiry as to whether or not he was a candidate and should then be sentenced to diversion.
Okay. If I could just circle back and quickly say why this is a case the court should dismiss the indictment, which was clearly the remedy, one of the remedies that the legislature anticipates for defendants who successfully complete the program, this is like 10 years later, the court's correct. And Mr. Soto, after successfully completing his probation without any violation and his drug treatment, has never been rearrested.
We don't know that.
Now, Judge, you can take judicial notice.
Of what?
Of the records in the database.
Is there any?
I have checked those records as recently as the day before.
Is this a part of the record now? There's something that, one, is it a part of the record? And two, is it something that we're now going to consider?
I think you should take judicial notice of the fact that it's a matter of public record, that he's now almost 70 years old and never been rearrested. The goal of the legislature in enacting this statute was fulfilled in this case. He addressed it, his drug treatment addressed the criminal behavior. The addiction was driving criminal behavior. His drug treatment addressed that, and he has never been rearrested. And as to the various statements that Mr. Soto, that the court faulted Mr. Soto for various statements that appeared inconsistent, I would just like to say that at the time the court was evaluating his application, he was a 65-year-old man who had survived a 45-year-long cocaine addiction.
But the issue, counsel, is whether or not, we would have to make a determination that the court should have sentenced the defendant to diversion, to a program. Yes. And how do we make that determination on the record? You're asking us, we make that determination now because 10 years later, he successfully completed probation and he has not sustained any new arrests according to you. So therefore, the court should have sentenced him to diversion 10 years ago?
No, I'm saying based on the record at the hearing, the court should have granted.
Based on what? The court.
Okay, he satisfied all the factors, Judge, under the statute that are supposed to guide the court's discretion in granting diversion.
Discretion. So we have to find that it was an abuse of the court's discretion?
Yeah. And we have a very unusual record here where it is apparent that it was an abuse of discretion because immediately after, on the hearing record, denying him the opportunity for diversion, the court offered him a plea bargain that was conditioned upon 5 years probation and drug treatment. In doing that, the court necessarily found the existence of all of the factors That is that
No, because one, I think the court said there's nothing to show that the drug abuse connected to this crime. In fact, he said, I was getting the coke for free. I wasn't dealing for that reason, and that is one of the factors, right? That's what he testified to. If we take him at his word, and there was nothing else but that was the one thing. I might have had it might be a more sympathetic argument, except he himself said, I didn't need the money to buy drugs. I was getting them for free. So that is one of the 4 factors, right? Are you saying your client was lying?
No, Judge, and the hearing court credited that testimony. But he didn't, just because he didn't have to go out and buy the drugs, he didn't mean they weren't contributing to his.
How do you know that? He testified to what he testified to. That's your spin on it.
No, Judge, I know that because his testimony was he was selling the cocaine to get some cocaine for his personal use.
I think said he was selling the cocaine to pay off bills. That's what he said. His wife had a lot of bills, and he was selling the coke to pay off his bills.
In Alston, this court plainly stated that the addiction does not need to be the exclusive or even the primary contributing factor. It only needs to be a contributing factor. Here we have a 61-year-old man riding around on a bicycle in possession of 66 bags of cocaine, whose testimony is credited that he is doing that because he does that. When he does that, he gets cocaine for his personal use.
But he says, I had to make money since my wife died.
Judge, it can be both.
But counsel, what the point is, in order for us to accept your argument, right, we would have to find that there was an abuse of discretion by the motion court, by the hearing court. And so in terms of the record, how on this record is it an abuse of discretion where there are inconsistencies, where there are issues as to whether or not the factors under the statute were adhered to?
Because when the court often offered probation conditioned on drug treatment, the court necessarily found that drug treatment was reasonably related to his rehabilitation or necessary to ensure he was going to lead a law-abiding life. That's the requirement under Penal Law Section 65.10 for the imposition of a condition on probation. So by imposing drug treatment as a condition, the court was necessarily finding that his addiction was contributing to his criminal behavior, that treatment was needed to address his criminal behavior.
Justice Chen has a question.
He also testified that he was hadn't been using 4 to 5 months. So that's inconsistent with what you're arguing.
I don't mean to interrupt, but that was really the source of how Mr. Soto got off on the wrong foot with the hearing court here. He had been abstaining for 4 to 5 months after his arrest. He was using cocaine at the time of his arrest. He voluntarily entered the drug treatment program and started abstaining. So when he was interviewed by the Manhattan Drug Court representative 4 or 5 months after his arrest, it was essentially truthful when he said he was not using cocaine. That doesn't mean he didn't have a cocaine problem. He was trying to abstain and doing so pretty successfully. And so when he admitted that he had used it because he was afraid he would be denied the program because his urine would test negative because he was abstaining, that was a very truthful, understandable, even sympathetic thing for a person to do who recognizes he needs drug treatment.
Thank you. You have time on rebuttal.
Good morning, and may it please the court. Matthew Colangelo for the respondent.
Counsel, clearly the legislature thought that dismissal is an appropriate remedy outcome for successful completion of diversion, right? So assuming that the trial court abused its discretion for this question, why is that an appropriate remedy then to dismiss the indictment?
Well, if the court gets to the remedy, which of course the respondent opposes and we can discuss, the dismissal is not the only remedy that the legislature intended.
Well, that's true, but my question is, why wouldn't dismissal be an appropriate remedy?
Well, because the basis for dismissal here, as I think came out in the colloquy between the defendant's counsel and the court, is based on factors that are not before the court, not before the people, and that are best left to the diversion court in the first instance to determine.
Are you referring to successful completion?
Well, successful completion of the terms of the probation, the lack of any criminal history since the completion of the terms of probation.
Short of dismissal, what are the other possible remedies?
Well, the court could, as the presiding justice pointed out, require the defendant to replead to a misdemeanor, which would be well within the court's discretion because the elimination of any criminal record in full was not the only goal of the diversion program. The diversion program was intended to give discretion to diversion courts in appropriate cases.
You're saying, if I heard you correctly, that one of the possible remedies here would be a remand to lower court for a plea to a misdemeanor, but defendant has not asked for that.
Or further proceedings, right?
Correct, or for further proceedings.
For further proceedings, and then the hearing court would make a determination as to whether or not a replead was proper, whether dismissal of the indictment was proper, or whether no further action was proper.
That's exactly right,
But
Your Honor.
that would require vacating the plea and sentence and starting all over again.
That's correct, Your Honor. So
And the defendant has specifically said he doesn't want that, right?
I don't think he addressed it.
So my understanding of the defense position is that what they want is dismissal of the indictment in full. If the court concludes that the defendant did not in fact waive his right to appeal, and if the court concludes on this record that the diversion court abused her discretion, then the respondent's position is that the only appropriate remedy is remittal and remand for further proceedings in front of the diversion court to consider any factors that court thinks are appropriate.
In terms of the abuse of discretion, that was my question. How on this record do we make a determination that there was an abuse of discretion? As I stated, there was a hearing that was held, and witnesses were called and witnesses testified. Now, your friend states that the fact that the defendant was ultimately sentenced to probation, and one of the conditions of the probation was that he complete a substance abuse program, that shows that the court did not take in consideration those factors under the statute, or disregarded the factors under the statute.
So we disagree because the factors under 216.05 are different from and more stringent than the factors authorizing a probationary sentence under Penal Law 65. And if it were the case that any probationary sentence with drug treatment meant that a diversion court abused her discretion in denying diversion, then there would be a lot more.
So, but is that not an acknowledgement that perhaps an acknowledgement that the use of drugs is somehow related to the criminal proclivities of the defendant?
I don't think so, Your Honor. I think, as Your Honor has already pointed out, the factual record here is quite clear, based on the defendant's own testimony, that the criminal conduct was not connected to his need to obtain funds to obtain drugs, because he said specifically that he needed money to pay off his wife's debt, and that he did not need money to buy drugs because he was getting those drugs for free. There's no evidence.
He was getting them for free because he was selling, correct?
Right.
It's not like someone was gifting it to him out of the goodness of his heart.
So, Your Honor, there's no evidence. Not only is there no evidence in the record to support that assertion by the defendant actually objected to questions by the people that would have established that the defendant was selling drugs, and the court sustained those objections. That's at pages 32 and 33 of the hearing transcript for the February 27th, 2018.
So normally when someone sells drugs for someone else and they receive drugs, that's the compensation. for selling the drugs.
But the defendant here specifically testified, without conceding, because the court sustained an objection, without conceding that he even was selling drugs. The defendant here specifically testified that he got drugs from the dealer because the dealer met his quota and didn't need them anymore. And he also told the arresting officer that the reason he needed money was to pay off his wife's debt.
He said it was like $85,000. He had a specific number. It wasn't because I need to feed my habit. It's because my wife, my passed on wife, had $85,000 in credit card debt, right?
That's exactly right, Your Honor. And
But that doesn't mean that he did not have a substance abuse problem that diversion would have assisted with, right?
well, that's correct, except that on that front, Your Honor, the diversion court was particularly troubled by the defendant's concession that after not using drugs following his arrest because he'd been scared straight, that he intentionally used drugs on October 31st of 2017 for the purpose of testing positive so that he would appear eligible for the diversion program. So that told the
Does the
diversion
trial court have before it evidence that he had a drug problem since for the last, I forget how many, 30, 40 years?
There was testimony in the hearing that the defendant who was in his early 60s at the time, had been using drugs since he was a teenager. So yes, Your Honor.
So the court necessarily what? Based on the contradiction that he had stopped from the time he got arrested, and then he started using again in the hopes of getting into the program, somehow that discounted those 20, 30 years of drug use?
Yes, Your Honor. The court focused on two factors. First, she was troubled by what she believed was his manipulative conduct in taking drugs in order to test positive to get into the program. She separately was looking at the statutory factor, which is whether participation in diversion could effectively address his drug use. And she pointed out that because he stopped after he'd been arrested.
4 months after 30 years?
Well, those weren't the only factors she looked at, Your Honor. She pointed out that his use had waxed and waned over 40 years, and she pointed out that
Which is pretty endemic of drug use, right?
It
so
is.
it's relapse.
That's correct, Your Honor, but it's not endemic of meeting the statutory factor that diversion is necessary to address the drug use. Now, to be clear, Your Honor, the people are not arguing here that there aren't competing factors, but the Court of Appeals held in People versus Sosa, this is cited in the People's Brief at page 25. The Court of Appeals held that the entire purpose of giving discretion to the diversion courts is for them to balance the compelling and often competing factors. And a reversal here would be to say that on this record, the diversion court, who sits in that part every day and has to make competing judgments about which defendants are eligible and which are not for a scarce resource, that the diversion court abused her discretion on that record. And the people respectfully submit that on this record, it was not an abuse of her discretion.
Thank you.
Judge, what the legislature intended here was to relieve defendants who succeed in completing their drug treatment of the burden of the felony conviction. That's a key part of what this legislation accomplished. Mr. Soto here did everything that could possibly be required, from initially voluntarily participating to he successfully, that's part of the court record before you, completed his probation without any violation. He successfully completed the drug treatment. He was...
Counsel, I want to make absolutely clear that the only remedy that you're asking from this court is dismissal of the indictment.
Judge, yes, because there would be no reason to deny him that wouldn't be arbitrary or just punitive. There is no
Counsel,
reason...
again, where in the record?
There's...
Don't we need a record in terms of what he's been doing during the 5-year period of time?
No.
In the entire 5 years of probation, there were no violations. There was no relapse. He completed the substance abuse, successfully completed the substance abuse program. All of that is before us in this record?
Yes, it's before you in the record.
Where?
He was discharged early. His performance on probation...
Is there something from the
It's
substance
on the
abuse?
court
Excuse me,
file.
counsel, please. Let me just ask a question, okay? I know you're passionate about this, and I certainly understand that. But where in the record does it tell this panel, the name of the substance abuse program that he participated in, that he successfully completed that program, that there's a certificate from that program or something from that program telling us that he successfully completed the program?
What I'm relying on,
Where in the record is there something that tells me the name of the program, how long he was in the program, the type of program, and that he successfully completed the program?
is the court file jacket, which reflects that he was discharged from probation.
So there's nothing that tells me the name of the program, how long he was in the program, or that he successfully completed the program without any issues, right?
I'm saying from the fact that he was discharged, that's reflected
From probation.
from probation without
So then why,
violation.
counsel, again, if we make a determination, and we would have to make a determination that there was an abuse of discretion by the hearing court, why then would we not remand, vacate this plea and sentence, remand for further proceedings, and then you can have a hearing before the judge who would make a determination as to the proper remedy, either dismissal of the indictment or replead to a misdemeanor or status quo?
Well, those are when a defendant successfully, this is a case where the sentence is over, Judge. He's discharged the sentence in this case. There's nothing left here to remedy, to give him any relief for the failure to give him diversion except dismissal of the indictment, or this court could modify if it chose, if it felt that it didn't want to grant the complete relief of dismissal, it could modify his felony conviction to criminal possession of a controlled substance in the 7th degree.
You didn't ask for that.
You didn't, yeah, and also, did he plead to that?
Judge, he had to plead.
No, I'm sorry, counsel, please.
Felony.
Could you just answer the question?
He had to.
Did you ask for that?
No, no. And I don't think that there's any basis for doing that as opposed to granting him dismissal, which is the relief that was contemplated by the legislature.
Thank you so much. Parquet Solar v. NLSPA.
Good afternoon, Your Honors. Robert Malionik of Latham & Watkins. I want to introduce my colleague, Michael Byrne, who's admitted pro hoc vice, and he'll be presenting the argument for the appellants.
Thank you.
Good morning, Your Honors, and may it please the Court.
It is now afternoon.
You're correct. Good afternoon, Your Honors, and may it please the Court. Michael Byrne for appellants. This appeal concerns Anel's responsibility to pay $77 million in interest under the terms of a guarantee by which Anel induced us to enter into a construction contract with Anel's subsidiary, which that subsidiary subsequently breached. Both sides agree that the guarantee's specific purpose was to guarantee Anel's payment of the exact kind of damages that were at issue here, which an arbitration panel determined that Anel Contractor Sub owed to us following 3 years of proceedings. Now, it's undisputed that we notified Anel of its subsidiary's breach and Anel's responsibility to pay us if its subsidiary did not prior to the guarantee's expiration. Anel insists, however, that we can't recover what we're owed because we did not make the particular demand for payment set forth in Section 4.2 of the guarantee, while the process to determine whether Anel Contractor Sub owed any money and how much was in its infancy. That argument is totally inconsistent with the language of the guarantee and the construction contract for at least 3 reasons. First, Section 4.1 of the guarantee expressly provides that appellants may demand payment from the guarantor following the subsidiary's failure to pay within 10 days, quote, except if the failure to pay or perform arises from a dispute that is pending resolution pursuant to Clause 20 of the construction contract, such as was the case here. The guarantee therefore expressly prevented us from making the demand set forth in Section 4.2 while the arbitration was pending. Second, Section 2.1 of the guarantee only allows us to demand payment under Section 4.2 when the amount in question is, quote, due and payable by Anel Contractor Sub under the construction contract's terms and subject to its limits. But under the construction contract, amounts subject to Clause 20's dispute resolution process are not due and payable because the contract provides that they're subject to dispute and that there's no amount due that an L contractor sub needs to pay while the dispute resolution proceeds. Finally, Enel's whole interpretation of the contract depends on the premise that we could have made Section 4.2's payment demand the minute that an L contractor sub refused to pay us the $136 million that we asked for. But Section 4.3 of the guarantee provides that once we make a demand under Section 4.2, Enel is obligated to pay us within 15 days. So for their reading of the contract to be right, you have to believe that we could have unilaterally determined that we were owed $136 million, ignored the construction contract's detailed dispute resolution, simply demanded the money from Enel, and they would have had to pay us within 15 days. That's obviously unreasonable, and contracts shouldn't be read to permit such absurd results. The last thing I'll say is, although we think the contract can only be reasonably read in our favor, those considerations at minimum show that it was inappropriate to grant a motion to dismiss, which can only be granted if the contract can be read in the unreasonable and unfair way that Enel suggests. Happy to answer the court's questions, or I can sit down and reserve my time for rebuttal.
Thank you.
Okay.
Good afternoon, Your Honors, and may it please the court. Gabriel Herman with Gibson, Dunn & Crutcher, LLP, for defendant, respondent, appellant, NL, SPA. Your Honors, the briefs in this case are lengthy, but ultimately the core question they present is simple. Does the guarantee mean what it says on its face? That appellants...
What would it possibly mean to say, except for if a failure to pay or perform arises from a dispute that is pending resolution pursuant to Clause 20 of the contract, except exactly what's happening here?
What it means is that in the event there is an arbitration pending at the time the predicate demand is made to contractor sub, the beneficiary has no obligation to wait 10 days before then proceeding to make a demand to NL.
That's not what that says, though. Let's be real. That's not. It says, it doesn't say that. It says the beneficiary has to make a 10-day demand, except in this circumstance. That's what it says. It's plain as day. The beneficiary shall first request, except if the failure to pay or perform arises from a dispute that is pending resolution pursuant to Clause 20. Is the arbitration pending pursuant to Clause 20?
The arbitration is now over.
I'm asking, but at the time, was the arbitration that you say that your guarantee expired, was at that time an arbitration pending pursuant to Clause 20?
Yes, it was, Your Honor.
Okay, so.
Respectfully, Your Honor, what the parenthetical doesn't say is, except if there's a pending arbitration, in which case beneficiary shall not make a demand on the guarantee and must wait until such time as the arbitration is resolved. And
I think that's exactly what it says, but maybe you and I disagree about that, so then it's ambiguous.
Respectfully, Your Honor, it doesn't say that. There are no provisions that say...
It doesn't say that you have to make a demand when an arbitration is pending, does it?
It says a few things. First of all, yes, it says it's valid only for claims made during the validity period before the expiry date, or in the limited exception that a claim is made on the guarantee within 15 days after the expiry date in respect of a claim that had been made to the contractor sub during the expiry period. So that scenario is the only exception to having a demand be made during the expiry period. The scenario here does not fit that exception. And more importantly, this guarantee says in 3 places, in 3 different ways, it's a guarantee of payment, not of collection. There is no obligation to exercise any rights against the contractor sub before making a demand for payment from NL. It says that in so many words. This is a guarantee of payment and not simply of collection. It then says in section 2.1 that except as expressly set forth in clause 4, which is making the written demand to contractor sub, it says that the obligation is in no way contingent or conditioned upon any requirement that the beneficiary first attempt to enforce any of the obligations against the company, which is the contractor sub.
Sir, does your reading of the language in the parenthetical in section 4.1 run the risk of rendering the arbitration provisions superfluous, that now we don't have to bother going to arbitration, let's just look straight to the guarantor?
No, Your Honor, because they don't have to go to arbitration. They were not obliged to arbitrate. The entire purpose of this structure with a guarantee of payment, and by the way, a voluntary arbitration provision in Section 3.5 of the construction contract, the whole point is that the beneficiary has the choice whether to go after Enel first or to go after the contractor sub first. And the reason they bargained for that was because they were convinced from day one that contractor sub would never be able to pay.
But isn't Section 2.1 of the guarantee cabined or burdened by, what is that, Article 4, Clause 4, and part of Clause 4 is 20.6, which says that no payment is due or payable except to the extent that such payment is subject to dispute.
20.6 doesn't say that a payment is not due and payable if it's subject to dispute. What 20.6 says is if there's a due and payable amount, which there was here under Section 9.7 and Schedule 9 of the EPC, upon calculation of the liquidated damages provisions, shall pay, contractor subs shall pay. So it was due and payable. 20.6 simply says when there's a dispute, and obviously when people dispute obligations, they don't pay them, you can't withhold performance or payment of other obligations while you work out that dispute. It recognizes no one will pay on those circumstances, but you can't use it to get out of other obligations. That's all it means. And Your Honors, again, they assumed from day one that they would never be able to collect from contractor sub.
Thank you.
I just want to make a couple of points in rebuttal. First of all, they rely on the idea that this is a guarantee of payment, not a guarantee of collection. What that means is that once you establish that something is due and payable, then you don't have to do what you normally have to do under a guarantee of collection, which is you have to go through a full legal proceeding, get a judgment, and then demonstrate diligence in trying to collect on that judgment from the underlying party before, then going to the guarantor. But what it doesn't decide is what is the circumstance in which you can actually pursue the guarantee. And here, in order to pursue the guarantee, there has to be something that's due and payable. And as discussed, it was not due and payable under the contract at that time. That's because the way that the construction contract works is that under Section 3.52 of the contract, it's kind of an interesting provision. When we think that they basically have failed to hit the guaranteed performance ratio that they're required to hit under the contract, we have the ability to make a determination and say,
So is it your position, is the defendant's position, you should have made a claim for something? I don't know what, because the number hasn't been fixed, but you had to make a claim. Say, I've got a claim, I don't know what it is, I don't know how much it's gonna be, maybe it's gonna be nothing, because the arbitration would go the other way against you, and I'd have no claim, but you had to say nothing, right? Something, but that, to me, seems specifically against the language that says, except if this is going forward.
Well, that's exactly right. But I would also just point out, we did make a claim. So on June 8th, 2020, before the expiration of the defects notification period, when all agreed that we were entitled to make a claim, we sent a letter to Enel and to Enel Contractor Sub, and we said, Enel Contractor Sub, you breached the agreement, you owe $136 million under the terms of the construction contract. And then we said in bold language, if Enel Contractor Sub doesn't pay, then we are entitled to collect from Enel under the terms of the guarantee. And as the Appellate case from the Southern District explains, all that making a claim requires is to make an assertion of a right. That's why in that case, an email to the opposing party was sufficient to make a claim. What they're trying to do is conflate the question of whether we made a claim with whether we made the specific demand under Section 4.2, and as Your Honor explained, we couldn't get there because of where we were in the process.
Thank you. DeRocho, the New York City Department.
If I may.
I'm sorry, did you have, I don't see that you had, did you have? I'm sorry, yes, I apologize. Yes, thank you.
Just very briefly, they didn't make a claim in 2020. They said, in case the contractor fails to pay the performance liquidated damages in the amount requested, the project company shall be entitled to request immediate payment from the parent company. They didn't request immediate payment. 3 years later, in 2023, they sent a letter saying, this letter constitutes a written demand by the project companies under Clause 4 of the EPC contract. They should have done that in 2020. They could have litigated the amount of the dispute directly with an L in a proceeding here in New York.
Except they were in arbitration, right? So
were not
let's
yet in
let's double our costs by doing both.
Your Honor, they were not yet in arbitration. They didn't commence the arbitration until 2 months later. And so, in fact, even under their own
2 months
reading,
after the letter?
2 months after that letter and 2 months after the 10 days lapsed that they had to wait under Section 4.1, 2 months later they filed arbitration. So under their own reading, they were not barred on business day 11 from making a demand on this guarantee. They weren't barred under their own reading, which of course we dispute.
No, the question
For
is
2
not
months-
whether they're barred, it's whether they're required. That's the issue, not whether they're barred.
Yes, they are, Your Honor, because the guarantee is valid only for claims made within the expiry period or within 15 days after the expiry period in respect of claims made to the contractor sub within that period. This does not fit within that timing. Thank you, Your Honors.
Thank you.
Excuse me, Your Honor, I just may I say one thing?
No, but thank
well,
you. DeRocha v. New York City Department of Corrections. Yes.
Good afternoon. May it please the court. Dorothy Weldon, New York County Defender Services, for petitioner appellant Otto Friedman. Mr. Friedman's continued detention constitutes an abuse of discretion, first because his dismissed and sealed cases were not a legal basis to continue harm cash bail, and second because on June 17th, the court failed to correctly analyze his securing order or explain the basis of
Was
its
there anything on the record by the bail court as to their consideration of the implication of the dismissal of the two new cases?
No, Judge, and that's one of the huge problems here, is that Judge Drysdale did not explain her decision-making process on the record or in writing in any real way. I can count at least 3 times that the court took the proceedings off the record entirely. We did submit a recent Court of Appeals authority to Your Honors, I believe on Halloween. This was a case that was issued from the Court of Appeals on October 21st that I think that really cements this, right? There are reasons, important, critical reasons, why CPL 51010 requires judges to explain their decision-making process.
So this would require a remand for further proceedings as to the setting of bail? Yep.
Well, Your Honor, here, I think under the circumstances of Mr. Friedman's case, that this court can grant the writ and release Mr. Friedman.
Based on what?
Based off of the fact that harm could not be met, there was no other basis to set or continue cash bail in his case. If the people want to make a subsequent application to increase supervision or to ask for other conditions, that's fine. But under these circumstances, because the court abused its discretion, and so clearly, based off of the record
How would
here-
this court be able to make a determination as to the harm analysis?
Well, let's begin with the plain language of CPL 51020 sub 3, right? This statute requires courts, just as it required Justice Drysdale on that day, to answer a straightforward question. Does a securing order comply with CPL 51010 now, after there's been a dismissal or reduction of the charges it was originally based on? And in Mr. Friedman's case, the statute demanded a straightforward right-line rule. Because defense counsel made her challenge under the appropriate subsection of law, because Mr. Friedman's underlying matters had been dismissed and sealed in their entirety, and because the court was then left considering a single indictment charging Mr. Friedman with non-qualifying
People
offenses.
state that the basis for the dismissal was not on the merits, but because of the fact that the complainants or the victims were unavailable or something of that nature?
Yes, they provided a whole mishmash of reasons why this dismissal supposedly was not their fault.
So should that mishmash not go back before the bail court to make a determination as to exactly what bail, if any, should be set, as well as any restrictions, et cetera?
No, and that's because 51020 sub 3 required the court to revisit and reevaluate the securing order on June 17th, and at that time, the elements of harm could not be met. There are simply, this in this limited subsection of cases, Your Honor, considerations of due process, the law of dismissal, the sealing law, and so on, outweigh the prosecution's desire to continue someone's incarceration.
So in making a determination as to the harm on harm, would the court, I understand that those two cases were sealed, but would the court need information as to what those charges entail, the actions that were alleged to have been committed by the defendant?
If I'm understanding your question correctly, it's what information would the court need from the underlying matters post-dismissal and sealing to make a harm determination? Well, that just goes to the factors of harm on harm, right? And those can't be met for a
So
number
my point would be, since they're sealed, we would not be privy to that information. And in making a determination, as you're requesting, that we simply, that the defendant be released, would we not need that information? And we're not privy to that information.
You're not privy to that information, and that's exactly why that information is not properly before the court on June 17th, nor would it be properly before this court now.
Well, that's what I was asking. And when making a determination, would the court not be in need that information or to consider? Shouldn't the court, when making a determination as to bail, right? Although the two cases were dismissed, wouldn't the court have an obligation or need to know what the two cases involved?
Well, the fact that the court did not have access to that information means that the court couldn't take it into consideration and means that harm on harm could not be met. I would also just add, if I see...
I understand that. My question is now, in determining what the proper bail, if any, should be, do we not need to know the underlying facts of those two cases?
No, the court does not need to know that. The court...
In order to make an informed decision, the court would not need that?
No, because the court should only consider information that's properly before it to make a determination, an individualized determination about what securing order is appropriate for Mr. Friedman.
Thank you.
Thank you.
Good afternoon, Your Honors. Franklin Gunther for respondents.
So can the harm on harm analysis be met under circumstances like this where the two underlying cases were dismissed and sealed?
So not if this were a de novo bail application, I think that this would be a different situation. But I think the context, the procedural context of this case distinguishes it, first of all, from the recent Court of Appeals decision, but also explains some of the bases that Judge Drysdale made her decision. So there was a de novo 51010 application in criminal court in the first instance. Then there was a Supreme Court arraignment where Justice Drysdale continued bail under 53040. And then, and this is...
Isn't the harm on harm analysis based on that they're underlying charges?
Yes, in the first instance.
If the underlying charges are dismissed, how can that analysis be met?
Well, as Justice Weber pointed out, if the people can establish that there's a reason for the dismissal that does not necessarily go to the merits of those charges, or as the people explained at the habeas court, that did not necessarily undermine their reasonable cause to believe that the defendant had committed those crimes, that is a fact that the court, first of all, it's in the record from criminal court arraignments, and therefore is information that can be considered, but it also means that the dismissal is not necessarily
when it's been dismissed and sealed. How would it get that information?
Well, so the dismissal, I would agree that the dismissal would restrict access to certain documents about those cases, for example, the felony complaint and other charging instruments, but it does not necessarily apply to, first of all, the representations that the people make about circumstances of the arrest in this case, but also transcripts from criminal court arraignments where the people explain the details of those.
My question was, again, in making that determination, is there not certain information on those two cases that were dismissed that the court could and should rely upon in order to make a determination as to bail?
I think that the charging instruments that were available at criminal court arraignments certainly wouldn't be available on a reconsideration. And again, this is just to sort of underscore, this is what distinguishes this case from a case like the recent Court of Appeals decision, is that in a 51020 setting, the defense is allowed to present a change in circumstances, whether it's on the law or the fact, and argue that that is a reason for a change in the application. Now,
But let me just interrupt you, but it doesn't, it's exactly on point in the fact that you have to put something on the record. You can't just say, this is what I'm going to do without explaining why, right?
So again,
And do we agree that there's nothing on the record?
Well, I wouldn't concede that
What do you think Judge Drysdale put on the record?
I think Justice Drysdale put on the record that she had considered whether the dismissal
And you think that's what the
necessarily-
Court of Appeals meant by explaining its reasoning on the record?
Well, again, the Court of Appeals decision is indistinguishable in an important way. That case had been dismissed and reversed on appeal, and it was basically the parties are back to square one at that point. And so at that point, the parties are in a situation of a 5-10-10 bail application, securing order at arraignment in the first instance.
But it's not distinguishable on the fact that the court specifically said that the judge has to put his or her reasoning on the record, right?
But in the instance of a de novo bail application, and I would just point the court to the XREL lead decision that we cite in our brief. Case discusses the difference between an application under 51020 versus an application under 51010. I would also note that the record from criminal court arraignments indicates that the defense did not even dispute that reasonable cause had been met on those underlying crimes, and that's at
Well, I'm sorry, I'm glad you mentioned that. So if you have a harm on harm under 510.103T, and part of the requirement there is that the prosecutor be able to show reasonable cause that the defendant committed both the underlying crime and the instant crime, that may be the way the statute reads. Are you saying even though there's been a dismissal of the underlying crime, you can still establish that there was reasonable cause to believe the defendant committed the underlying crime?
I'm saying that the court can consider the basis for the dismissal and determine whether the dismissal necessarily undermines the initial reasonable cause determination.
And is there any support in the statute for that approach? I mean, it's not an unreasonable approach, but is there any textual support for that?
Well, as we point out in our brief, I think the and this gets to the 51020 discussion specifically. Under 51020 sub 3, the dismissal has to be such that the factors under 51010 are no longer supported, and we would suggest that basically means that the court has to consider or can consider whether the reason for the dismissal would undermine the initial determination. Now, as the people indicated, the reason for the dismissal in this case did not necessarily go to whether they had reasonable cause to believe that the defendant had committed those crimes. And so that initial determination, Justice Drysdale did not necessarily have a reason to think that the initial reasonable cause determination was somehow incorrect or mistaken. And so I think these are things that the court can consider. What I think petitioner is requesting is that the dismissal automatically would require a reversal. And what we're saying is that the court can still exercise the discretion to...
Where do you see that? It requires an underlying offense. If there's no underlying offense, what could the court consider?
Well, so again, in the first instance, we would have to establish reasonable cause to believe that those crimes were committed. If those cases are later
But I mean,
dismissed,
isn't dismissal isn't dismissal basically nullify that?
it nullifies those cases going forward. And I think this case would be different if, for example, those cases had been dismissed before the people made.
Well, why would the people dismiss them if they were, all right.
Well, I mean, I'm just
Forget it, yes.
hypothetically, if those cases were dismissed and we make a bail application in the first instance in criminal court and we don't have the felony complaints, then I think the criminal court would have a reasonable, it would be reasonable for the court to speculate, I don't know that you've established reasonable cause. But again.
Thank you very much.
Thank you.
Just two very brief points. the first one thing I want to hammer home is that the legislature is actually quite expert at drafting hearings with burdens of proof and so on when it comes to modifications of securing orders. And I'm thinking specifically about 51040 and 53060. If they intended to open the door to this morass, and if they intended there to be litigation over whether the reasons for dismissal implicated reasonable cause and so on, I think the legislator would have indicated that, and they would have provided.
So under your view, the dismissal of the underlying charges takes it out of the harm on harm analysis?
That's correct. The last thing I wanted to point out is that my adversary's position boils down to this, that prosecutors should be allowed to continue harming people based off of dismissed and sealed cases, so long as their office maintains, we can't prove he's guilty, but he is. We dismissed and sealed the case, but it wasn't our fault. That type of standard has no basis in the plain language of any of the statutes at issue, and I would argue no basis in our justice system, period. Dismissals matter, and this court should read 51020 sub 3 and 51010 and attendant law to mean what they say.
Thank you.
Thank you.
Anjan V. De Jesus.
May it please the court, Miles Linevsky of Eustace Prezioso and Yapchanik for the appellant of Reinstein Ross LLC. This is an appeal from a slip and fall on ice case on the sidewalk adjacent to 29 East 73rd Street. My client, Reinstein Ross, was the basement tenant. In that space, they operated a jewelry.
So you moved for summary judgment, is that correct?
That's correct, Judge.
Okay, and you moved for summary judgment on the basis of what?
We moved for summary judgment against the building owner, which was granted on the basis of their.
But as to the plaintiff?
As to the plaintiff, we're moving under the basis that there was no duty owed by a commercial tenant to a passerby for the condition.
So you had a lease agreement with the owner, right?
That's
in
correct.
terms of snow removal, and you're responsible for the snow removal.
So the motion court correctly decided that the owner had waived those provisions of the agreement. The lease was in place for 32 years prior to the date of this accident, and the owner testified herself that there was no expectation.
So plaintiff claimed that she was stepping over snow from the street, stepping it over onto the sidewalk, and then as she stepped over this pile of snow, she slipped and fell. So this was abutting your premises, is that correct?
This was abutting the co-defendant's premises.
Okay, but did you show that you did not cause the formation of the ice and snow, that you didn't try to remove it, or that in your attempts to remove it, you didn't create some type of dangerous or hazardous condition?
The record is replete that there were no attempts expected of my client. I will concede that there was no evidence promulgated that whether or not there were efforts undertaken. I will notify the court that there were.
So you conceded there's nothing in the record from your representative, because I think you did produce a representative who had no idea as to what occurred, right?
Well, I wouldn't go that far, Your Honor. The witness that appeared was not employed.
She said she had no information or no knowledge of what she, I guess, was termed as the day-to-day workings, so that would include any snow removal procedures?
She was hired as the CEO following the date of this accident, though there was testimony that there was no expectation or communications regarding my client removing snow in the 32 years prior. It was done by a gentleman across the street.
Benjamin? Is that Benjamin?
Mr. Benjamin, yes. And Mr. Benjamin also testified that at times there was a cafe down the block, actually where plaintiff was on her way to, that would clear snow to the nearest avenue, Madison.
Yeah, but in support of your application, your motion for summary judgment, didn't you need to put in something in terms of what you did or did not do that day, what you were required to do that day, which you either did or did not do? I mean, the record is kind of sparse and deficient in terms of exactly what you did or did not do.
Well, Judge, it's our position that there was no duty owed for my client to clear the sidewalk in any way.
Well, you may not owe a duty, but you could voluntarily assume one, right? If you were to take an affirmative action towards cleaning the sidewalk, right?
That's
Okay.
agreed,
And so
Your
to
Honor.
Justice Weber's point, your motion, and even though you are the defendant and would have no burden at trial, now you've got to make an affirmative showing of entitlement to judgment in a matter of law. So did you put in any evidence demonstrating that, in the first instance, you did not undertake any snow removal or remediation measures on that day?
Your Honor, there is the testimony of the building owner that there's never been any expectation or practice of my client clearing snow. There was testimony that Reinstein Russ didn't own any shovels, and this was before business hours. This accident happened at 8 o'clock in the morning, and the subject store is a jewelry store.
The accident happened at 8 o'clock in the morning. I thought she was going to meet someone for lunch.
She was going to meet somebody for coffee in the morning.
Okay. But again, there, in the lease agreement, it did state that you were responsible for snow removal.
And again, it's our position that the court below correctly determined that that portion of the lease had been waived by the course of dealings between the parties.
Waiver on a motion for summary judgment.
Well,
And certainly there's testimony from somebody that somebody from your place was shoveling during periods of time, right?
Well, I would disagree with that, Your Honor. There is no testimony that anybody from Reinstein Ross had shoveled in any meaningful way.
Isn't there a security guard doing that?
There was an individual who stated that on occasions he or she had observed your security guard shoveling snow.
Your Honor, I'm not familiar with that portion of the testimony. I do apologize.
I mean, it
But
was in the record. I'm not stating that that's conclusive, but I mean, there was that testimony. That coupled with the fact that you presented no one who stated what your procedures were or were not.
And what I will submit is that there was testimony that Reinstein Ross did not even own shovels at that property.
You didn't own shovels?
There were no shovels kept at their property in the lower level unit at 29 East 73rd Street.
Thank you.
Good afternoon, Michael Eisman for the respondent. Unless there's questions for me, I'll rely on my brief.
Oh, thank you.
Thank you.
Wait, he has rebuttal.
That's right. And I would just like to add that the reasoning on the motion below, the court below has found a duty owed by a tenant under 16-123, and we're submitting that that's just a misreading of the statute. There's a qualifier in the statute that it only applies to any of the listed individuals having charge of any building or lot of ground in the city, and the court below had just read past that, which is a misinterpretation of the statutes. There is no statutory duty for a tenant to clear snow.
Thank you.
If there are no questions, thank you, Your Honors.
Robinson v. Delgado.
Good afternoon, Your Honors. May it please the court. Matthew Corcoran for the defendant appellants, Delgado and GVC Ltd. Your Honors, our motion for summary judgment was denied because of a question of fact, and there are two main pieces of evidence that both the court and the respondents focused on when stating that there was a question of fact, both of which we contend are improper. First, the rationale in Justice Chin's order where he stated that plaintiff, who was a backseat passenger in the co-defendant's vehicle, testified that she felt that the impact to the vehicle that she was in came from the back. He claimed that that created a question of fact, and respondents also argue as to how this accident...
Didn't she also testify, I was giving him money for at least 30 seconds and in the car before we got hit, right?
Correct.
It wasn't just that.
And as she was giving him the money, the taxi was stationary.
Well, she said she's asked, Your Honor, if the car pulled away before the accident, and she did not remember. That is her testimony.
She said the taxi was stationary for about 30 seconds before struck by the bus.
Correct,
And
but...
right. So she said it was stationary during that period of time as she's giving the driver the money.
Page 145 of the record, Your Honor, she's asked, question, before the impact or accident occurring, did the driver pull his vehicle out of parking? Answer, I don't recall. There's a whole line of
But
questioning
she
there.
also testified, you can't ignore the fact that she also testified. The taxi was stationary, I was giving him money when we got struck.
About 30 seconds passed, she got into the vehicle. During that period of time, she's giving him she's giving him the fare. As she was handing the driver the fare, the car got hit.
Correct, yes. I'm not trying to ignore that, Your Honor, but the point I'm trying to make is Justice Chin's decision. He talks about how there's a question of fact as to whether this is a rear-end hit or a sideswipe based on plaintiff's testimony that she said she felt the impact was to the back. And my point here is that where there's testimony that is in stark contradiction to all the record admissible evidence, and that's the law of this court, where there's objective physical evidence that shows the testimony is just plainly incorrect, we don't have to consider the
Well, I
plaintiff's
guess
testimony.
because if, in fact, the vehicle is stationary, it could not have gotten hit from the side. It had to have gotten hit from the back.
But, Your Honor, there's an invoice from the insurance carrier for the co-defendant's vehicle because they brought a subrogation action that was joined for trial.
I understand that, and there was testimony also. I think that when the bus was taken back to the garage or whatever, that there was a dent on the side by the door.
By the exit door
By
for the
the
bus that
exit
sits
door.
behind the engine in the cabin all the time, yes.
Exactly. But the point is, are there not now issues? It's inconsistent. There are issues of fact as to whether the vehicle was struck from the rear, whether it was struck from the side,
But
etc.
Your Honor, again, we have the invoice from the insurance carrier that says all of the damages to the front driver's corner of the co-defendant's vehicle. We have the expert report that was submitted by plaintiff, which we do contend separately it should be not considered by the court. The expert offers absolutely zero background, his credentials, education, experience, what his work is. So we argue that that should not be considered in the first instance. But if the court does consider it, he also says, based on my review of all of the evidence, the damage to the co-defendant's vehicle was to the front driver's corner of the car. There's no physical evidence. That's also corroborated by the police report as to the points of impact. There's no physical evidence to show that the co-defendant's vehicle was hit in the back. Even in the subrogation action that they brought, they never made a claim for any damage to the rear of the vehicle. So again, based on First Department precedent, which we do have in our brief at page 11, where the testimony is, quote, flatly contradicted by documentary evidence, those factual conclusions do not need to be considered by the court. And that is my point as to why Justice Chin was incorrect in finding a question of fact as to, based on plaintiff's testimony. And I can finish up the rest of my argument on rebuttal, Your Honor. Thank you.
Good afternoon, Your Honors, and may it please the court. My name is Kristen Janaris for the plaintiff respondent, the injured passenger in the taxi's vehicle. Even if the impact to the taxi's vehicle was to the front side of the taxi as opposed to the rear, summary judgment still remains improper here based on the competing accounts of the accident engendered by defendant's own motion papers. To that end, we have the police report, which documents the taxi driver's competing account of the accident, that he was in a stopped, double parked position at the time his vehicle was struck by the oncoming school bus. Then we have—
Would the damage to the truck that your friend is highlighting, would that, if we accepted that was the damage caused by this particular accident, would that fatally undermine your client's narrative?
No, because it's perfectly consistent with a double parked taxi remaining stationary, a bus passing down, it's a single lane roadway on Caldwell Avenue, and attempting to get around in front of the taxi. And that line of point of contact would match up, the front side of the taxi and the right side of the bus's passenger door.
And isn't it possible that the bus bounced off the back and then hit the front? I mean,
It just goes to show that there are so many tribal issues, in fact, unresolvable issues as to how this accident happened. And as was also pointed out during my adversary's argument, we have the plaintiff's deposition testimony. She says, I was in the car 30 seconds of getting into the taxi. As I was physically, she used the word literally, handing him over the cash fare, that's when the car was struck. That also fully corroborates the account in the police report that the taxi was stationary. She also testified on no less than 4 occasions that the taxi was the vehicle that was struck, not the other way around. She repeatedly testified, we got hit, we got slammed into, we were struck when I was handing over the money, yet raising further tribal issues of fact as to the happening of this accident. And for those reasons, Your Honors, summary judgment was appropriately denied here. There are just unresolvable issues of fact as to how this accident occurred. Thank you.
Thank you.
Very briefly, Your Honor, regarding plaintiff's testimony where she says, we got hit, we got hit, we got hit, she also concedes that she didn't see the accident. She never got out of the car to look at the accident or the points of impact or the damage to the 2 vehicles. And relating to also to the points of impact, the only damage to my client's school bus is to the exit door. I'd posit if my client hit the plaintiff's or the co-defendant's vehicle in the rear, there'd be damage to the front of my client's bus. My client's bus can't Tokyo drift into the co-defendant's vehicle and get hit in only the passenger side exit door. There would be damage to the front of my client's bus if this was a rear-end hit, and there is none. We've never claimed there is. There's never been any testimony that there was. The police accident report doesn't indicate that there was. And then the statement contained in the police accident report by the co-defendant, we argue, is inadmissible hearsay. Now, through an unfortunate series of events, there's no testimony from either driver in this case. My client passed away before he could testify. The co-defendant, who is a respondent but is not here today, their client was precluded from offering testimony. So that statement in the police report where he claims that he was stationary when he got hit is inadmissible hearsay. And while that can be admitted on summary judgment, there has to be something that corroborates it. And I argue that there's not here. Unless there's any questions, thank you, Your Honors.
Thank you. People v. DeQuandi.
Good afternoon, Your Honors. Isabel Patkovsky on behalf of the Legal Aid Society for Daquan. The courts have held time and again that anxiety is a normal response to being stopped by the police. Here, the police's conduct towards teenage Daquan was egregious from
So we don't get there if the waiver is valid, right?
Thank you.
Correct, Your Honor.
And what's the problem with the waiver here?
The waiver is invalid for several reasons. First, and most seriously, the court did not tell Daquan that he was waiving the right to appeal suppression. This was the main issue in Daquan's case, and the court entirely skipped over it, which notably, and this isn't dispositive, but notably is out of...
Was that warning in the written waiver?
It was, but that puts this case pretty much on point, I would argue, with People v. Colon, decided by this court, where the court said that a perfect written waiver cannot cure a colloquy that would suggest to a lay defendant, particularly one like the client there, and the client in this case, who had no prior convictions, that he was waiving nothing but trial rights. And that
is represented by counsel?
I'm sorry?
He was represented by counsel?
He was, Your Honor.
He stated on the record that he had reviewed the written waiver with his attorney?
Yes, he did. We still believe that that is not sufficient for a young person like Daquan with no criminal history whatsoever, and where the waiver not only did not...
Did the waiver follow the model colloquy?
The oral colloquy did not follow the model colloquy.
Well, how was it different?
Because the model colloquy specifically says that where a motion to suppress has been denied, the should inform the defendant that he is waiving the right to appeal suppression. And we cite that in our reply brief. That is part of the model colloquy.
So what aspect of the oral colloquy could have suggested to the defendant that he was not waiving the right to appeal the suppression ruling?
The fact that the court never said you are waiving the right to appeal suppression. And on top of that, the court also did not tell him that he was not waiving the right to appeal youthful offender eligibility, which just so happens to be one of the other major issues in his case. In other words, this is not a case where there was some technical point that the court missed. The court actually missed the substantive things that were most important to Daquan. So
the rule then that we would have in this department is where there is an adverse decision to the defendant on a suppression motion, and then there's subsequently a plea with an appeal waiver, that in order for that appeal waiver to be valid, the court must expressly tell the defendant that one of the issues that the defendant is waiving the right to appeal of is the suppression ruling itself.
I think this court and the other appellate divisions have really kind of eschewed making hard and fast rules. Courts have emphasized time and again that it really is a fact-specific determination. So I don't think Your Honors need to go so far as expressing a clear rule like the one Your Honor
You're
just
stating that because this was not done in this case, then the waiver is invalid.
And because, in addition, the court did not mention YO eligibility, the court did not tell him about the right to counsel on appeal. And again, this was a young man. He was a teenager at the time of both of these offenses. He had no criminal history whatsoever. There's nothing in...
But is there anything in the record that would suggest that when the court says to the defendant, did you go over the written waiver with your attorney? And he says yes, that his attorney didn't go over those issues with him? Going over the written waiver, which we all agree actually says those words in it?
And let me just say, the court's asked, did you go over the written waiver with your attorney and fully understood, well, it says fully understood it, and the defendant said yes.
That's correct, but I don't believe there was any indication in Colon that there was a problem like that either. And yet, this court held that a thorough written waiver is simply not enough in the circumstances where the colloquy would suggest to a lay defendant with no criminal history, which is exactly what we have here.
That's why I take issue, because point to me what in the colloquy would suggest that he could not appeal the denial of suppression. Your argument, as far as I understand it, is that the fact that the court didn't affirmatively say that that's what you're giving up, that's the problem.
Well, yes, because the rights that the court did talk about are trial rights. The court talked about, you're giving up the right to a jury trial, you're giving up the right to testify, you're giving up the right to call witnesses. Those are trial rights. The court
also told him that he's giving up the right to contest the judgment of conviction.
That's correct, but I'm not sure that...
And how about
the right to have the appellate court consider most claims of error, whether the sentence is excessive, should be modified.
But again, I think to a young person with no criminal history, the examples that the court was giving would all be suggesting that these are basically things that happen when you go to trial, and that for all intents,
Well, again, the only thing, counsel, is I think that's why you have an attorney, and that's why the attorney is counseling the defendant, and that's why the court asks whether you've spoken to your attorney about this. Justice Scarpullo?
I was just going to say also, and among the limited rights that will survive the waiver are the voluntariness of the plea, the validity and voluntariness of the waiver, the legality of the sentence. Those aren't trial rights, right?
Those are not trial rights,
Right,
that's
so
correct.
she didn't just say trial rights, right? There are other things that the judge among, and in fact said among the rights.
But the court did leave out the substantive rights that were most important to Daquan. They were the issues that were actually in his case. And I think given...
Has there been a case where we or the Court of Appeals has reversed based on an inadequate, or ruled that the waiver was inadequate because the court didn't hit the salient points as to that defendant for that case?
I don't think Your Honors have ever said that specifically. I do think this is on point with Colon, where what Your Honor said was the colloquy, setting aside the written waiver, which nothing in Colon suggests that the written waiver was anything but thorough, nothing in Colon suggests that counsel didn't go over the waiver, that the colloquy taken on its own terms was not sufficient for the defendant in that circumstance to understand the rights that he was waiving. I would love to get to the substance of the suppression claim.
We'll love to hear that on your rebuttal.
Okay,
Thank
thank you.
Good afternoon, Your Honor.
So, counsel, assuming the waiver was invalid, can we move on to the issue as to the determination of YO?
As to the YO determination,
Yes.
we
Well, the suppression issue as well as the YO?
yeah, well,
Conceding the YO portion, correct?
yes, we concede the YO portion that that
Okay.
indictment has to be remanded for consideration of YO treatment.
And the suppression issue?
The suppression issue is covered by the waiver, as Your Honor suggested, and I think
My colleague just started with the premise that we're going to assume.
We're going to assume.
that the waiver's not good.
And if we assume that it's invalid, I think that our respondent's brief does a really detailed, thorough job of explaining why the police conduct was reasonable at every step, including that, after seeing from a short distance, the traffic violation that initiated the stop, the defendant was really excessively nervous. It's quite striking in the
what you call the frisk of the backpack after the defendant had been removed from the car, had been frisked, and nothing was found.
Right. So that has been consistently held to be okay, even after the backpack. Sometimes it's a fanny pack, whatever sort of bag or kind of container that was in the possession of the defendant. Even after that container has been reduced to police control, and it's not within the immediate grabbable area of the defendant who's now in custody. Or detained, in some way. The key timing was the container in the grabbable area at the time of the arrest or detainment or kind of separation.
Right?
The separation from the bag, from the container.
If the defendant is moved, the occupant of a vehicle is removed from the vehicle, surrounded by a number of officers, how is a bag on the floor underneath a seat in the car within the grabbable area?
Because of the timing issue that I was just alluding to. It's whether it's in the grabbable area at the time that the defendant is kind of taken and detained and separated from the container. And that's been the case in this department and in the Court of Appeals since the 80s. The briefing doesn't actually get into this very much, but I know from another case, I can't remember the names quite off the top of my head from the Court of Appeals. But the fact that the defendant is subsequently separated from the container does not kind of diminish the exigency, even though the police have reduced the container to their own custody.
Matter of when you gauge grabbable.
Exactly. It's a matter of where it was when the police kind of separated the defendant from the container. Thank you, Your Honor.
If this court reaches the suppression issue, Mundo really decides this case. You have a scared, unarmed teenager who's told the police, "I'm scared because of all the police videos I've seen." He's surrounded by multiple armed officers, and Mundo says, once a car passenger is removed and frisked without incident, the police cannot go back in the car. That is this case. And the exception under Carvey and Newman for a substantial likelihood of weapon and actual and specific threat to officer safety is not this case. Because again, at this point, all you know is Daquan has nothing on him except a phone charger, and he's really scared. And this court has never held that establishes reasonable suspicion, let alone more than that. I'd also like to emphasize that that same scared kid that got accosted by the police that day is the one who subsequently pleads without being told by the court that he's waiving the right to appeal that suppression decision. And again, I want to emphasize that does deviate from the model colloquy. Finally, with the remaining time that I have, I would like to briefly address the retention issue, as that is an issue of first impression for this court. I believe that respondent has conceded that that is not barred by the appeal waiver, just like YO, because it's a jurisdictional issue. I would point this court to the Second Department's decision in Lloyd F., where the Second Department said that gun cases involving a display of a weapon should be transferred to family court unless it is in furtherance of a crime other than possession of the weapon. That's really the only way to make sense of CPL 722.23, because otherwise half the statute becomes completely redundant. Cases are meant to go to family court. Children are meant to be treated as children unless they display a weapon in furtherance of a violent crime. And anytime someone displays a weapon, they necessarily possess the weapon. So that language just doesn't make sense.
Yeah, but you could possess a weapon without displaying it, right?
You could, but then it would
It's
definitely.
an extra act when you actually display it.
The display is, but the statute has two parts: display and in furtherance of a violent offense. If it's just displaying and it's not in furtherance, then it's supposed to be treated as a childish act that is better remedied by family court and not criminal.
Did your client preserve that issue?
No, and I believe it doesn't need to be preserved, again, as respondent seemingly concedes, because it's a jurisdictional issue, as I think it's the Third Department or the Fourth Department decided in People v. Aaron v.
Thank you. Thank you both.
Thank you.
Last case for argument is matter of Strasser.
Good afternoon, Your Honors. My name is James Kaplan. I represent with the firm of Greenberg and Kaplan, and I represent Ika Braca, who is the executor and previously guardian of the person of Edward Strasser. This is basically an appeal of an award of $319,000 in legal fees to the successor guardian, Brian Raffan. Hopefully, I want to be brief, but the original guardian was replaced at the requests of my clients,
Right, so the allegation was that the original guardian did not proceed appropriately, and so there had to be litigation against that guardian. Is that correct?
That's correct.
Okay, and so the respondent in this case Raplin took part in that litigation. Is that correct?
Well, he took part in that litigation, but he hired a litigation counsel who charged close to $500,000 to pursue the litigation. Now, they were somewhat successful in that they recovered in a mediation $850,000, and my client refused to accept that. And then
I thought that you were objecting to Raplin's
we are
work.
rejecting to Raffin's fee.
Oh, his fee.
They
Okay.
agreed.
Not the other gentleman, not the other attorneys.
They reluctantly felt they had to agree to that on Raffin's recommendation, and
Okay, so Mr. Raplin now apparently he was more familiar with this type of litigation than the attorney who was actually hired, retained. And so the statement.
I'm sorry, Your Honor.
Is that not correct?
No, that's not correct. The attorney who was retained was a securities litigator who did most of the work on this kind of litigation. Raffan said that he was not a litigator. He was an estates litigator.
Right, and I thought that was the whole point, that this attorney was not familiar with estates work, which was required by this litigation, and that's why Mr. Raplin did more
I think
to
what was
assist him.
required by litigation was a securities litigator to show the defalcation of the prior guardian. Mr. Raffan was an estates litigator. He was the guardian, so he could assist perhaps, but the heavy lifting was to be done by the securities litigator, and that was what was told to the clients. It was never told. What was told to the clients was, well, he's going to do most of the litigation. He's a real securities litigator, and Mr. Raffan, who's an estates litigator and a guardianship lawyer, might be assisting him in certain respects. But what's happened is that so they awarded $500,000 to the securities litigator. That was agreed to under pressure, by the way, by my clients who reduced his fee by about $100,000. But the real issue in this case is that Mr. Raffan is seeking close to $300,000, and she awarded special litigation fees to Raffan for areas that he wasn't familiar with. That's the problem here.
Thank you. You have time in rebuttal.
Can I just say one other thing?
Yes, on rebuttal.
Okay, all right.
Good afternoon, Your Honors. Jillian Rosner for the plaintiff petitioner respondent. Just to talk about the surcharge litigation, first of all, Mr. Raffan retained special counsel and experts, which was actually prudent because it was a very complicated financial securities asset issue that the former guardianship just mismanaged. And as this court knows, and there's other cases from the Third Department, that it's wise to do that. And just to point out, at 139 to 141 of the record, which my adversary didn't discuss, was that the Braca and Mrs. Strasser approved all of these fees. Well, first of all, the expert fees and the counsel fees were approved by the court. Mr. Refan produced this to the court, and the court approved it. But at 139 to 141 of the record, the order of the agreement it's approved. So they knew about it.
Well, I mean, your friend intimated that perhaps there was some type of coercion or they were forced to approve.
There's no evidence of of coercion on this record. There's been no proof at the hearing, which was extensive.
So that was my point, though, that Refan, and I mispronounced his name, apologies, that he stated that he worked with this attorney whose specialty was securities. He reviewed the documents. He assisted in the answering of the interrogatories, prepared for depositions, involved in the strategy. And Refan was acquainted with the guardianship world, which the attorney who was retained was not. And so the court made a determination based upon all of this that Refan was entitled to those fees.
Correct. And exactly. So at the hearing, which is in the record, Mr. Refan explains everything that he did with regard to this litigation. He was not only a fact witness, but he was an expert witness on the mental hygiene law. So he participated in all forms of discovery, and he was preparing to be produced as an expert at trial if it didn't settle. If you look at the time records, which is what the court gave a very detailed discussion and explanation for its award with regard to the surcharge litigation. And if you look at the timesheets at 34 to 56, Mr. Refan separates his work in the surcharge litigation from his extraordinary work in the guardianship part of it, and it's substantiated. His fee, by the way, it's important to note that his fee for both the surcharge litigation and the guardianship was reduced by the court. If that doesn't show even-handedness, I don't know what does, but it was reduced fairly significantly, including from his time and his fees. So he didn't just sit by, he was actually characterized by the trial court here as co-counsel with Mr. Dvorkin. He didn't just sit there, he participated aggressively, and he brought potential knowledge had it gone to trial. But one other thing before I sit, this yielded I don't know where my friend, so to speak, gets $850 from. This yielded $1.2 million to the estate. This mediation is settled for $1.2 million. And that obviously is a benefit of the estate. Before I sit, the record is really, really clear, and the court gave a really detailed decision and order explaining the award as well for Mr. Refan's extraordinary services as extra extraordinary services for purposes of the guardianship, and that's in the record, and that's at the hearing. It also was less than what Mr. Refan was asking for, because if you notice, after the referee Tempesta issued her initial report, that there was 2 properties that weren't allocated in the SCPA 2307 compensation commission that the court asked for her to then reconsider. Then there was just an enormous amount, several years worth of litigation as a result of the objectants, or actually really BRCA, not so much Mrs. Strasser's, contesting all of the additional fees, all of the additional time and effort, which, by the way, meets the 6 elements of the Freeman test for awarding litigation attorney's fees. And it just is between the court order and the hearing, every award by the court is substantiated and reasonable, especially in light of the fact that it was reduced from what Mr. Refan was arguing. So his meticulous timesheets really, and the hearing really sets the stage for his involvement in this very complex guardianship and what he actually uncovered and unearthed in this country and outside the country with regard to assets that the former guardianship just mismanaged, and that was the benefit to the estate, which is a very big, important part in considering whether his fees are substantiated and reasonable.
Thank you.
Thank you.
Your Honor, I tried this case, the fee application before Judge Sharp. It is absolutely not true that there wasn't testimony as to that there was some coercion on these widows to settle with Mr. Dvorkin. it's also true that the guardian, Rafan's, one of the 7 factors that one looks at in setting compensation for an attorney is, one of the most important factors is the amount involved and benefiting resulting to the client from the services and the results obtained. The bottom line here was, because there were fees aggregately of more than $1 million, close to $1 million, is that there were no benefits to my client. There were no benefits to the estate. It all went to the lawyers. It's this kind of abuse that has my client upset. And I think it's something you ought to think about. This is the first, I've tried 10 guardianship cases. This is the first time I've ever argued before the Court of the Appellate Division. But it seems to me that the issue here is, is this a reasonable fee when the client gets nothing and the lawyers get all the benefits? We view the special application that was awarded to Mr. Rafan as excessive. It's a question of basic fairness. I mean, is this what we're going to do in this guardianship area, where the lawyers get everything and the client gets nothing? Look at the record here.
We will do so. Thank you.
Okay.